told me they have seen city workers throwing trash on my property before. I do not have evidence of this, but I do believe it's true. A few days later, that Christmas decoration was magically gone. I picked up the other 4 items and the code violation went away. I pay someone a monthly service to keep that property cleaned up, but there was no way that someone can be there day and night picking up 1 cup or 1 beer can or trash that pedestrians and other people throw in there every day. It seems like the property is cleaned up, and the next day I get a code violation with a photo of a few pieces of trash the day after it's been cleaned up. Fast forward to now and another code violation for the same property. This time it was a pile of debris that had not been removed after Helene and 1 stump from a palm tree that had died and been cut down. The stump was put out to the street for pickup, but no one picked it up. This was all part of the ongoing Hurricane Helene cleanup and also waiting to see what plants would revive and live. We've already heard that from several people here today. We're supposed to wait until to see if these plants live. But then I got a code violation for it. The stump and debris have been removed at this point. There are so many properties still in complete disrepair and a huge mess here in St. Pete Beach. I do not understand why code enforcement continues to harass one single citizen for over 20 years. I'm a female senior citizen who lives alone, and I now suffer from PTSD. This is diagnosed PTSD directly related to the ongoing harassment by St. Pete Beach code enforcement. And that fence is, I don't have to tear that fence down. I can repair it or do whatever. But first of all, I was forced to build that fence. I told them it was a bad idea, and it's not on my property, it's in the city easement. So as far as I'm concerned, this whole thing is about harassing a female senior citizen in St. Pete Beach. Thank you.
Thank you.
Thank you for letting Ms. Maureen exercise her First Amendment right.
Would you like to see the pictures of the Christmas decoration and the other things that were on my property?
I actually, this has nothing to do with this particular violation. I don't need to see them.
Well, it does. This is the repeat offender part of this violation.
Well, actually, it's not. The order that this is the basis of on was issued in August of 2024, which would have been prior to Christmas, which would have been prior to what you just testified to was in January.
Right, but this was on my property in May. This was laying on my property in May.
Okay, and the pictures that I have for me, if you would like to show them, by all means, this is your case as well. The property pictures that I have now are just of a broken 3-foot fence, the palm frond, the root ball from the palm tree.
Which are gone.
Right,
gone,
and I think the city also agrees with that. And then the vegetation on the side. I don't have anything on here with regard to a Christmas decoration, but again, this is your case. So if you would like to put that into evidence, I would certainly consider it.
There's the Christmas decoration that the city threw on my property. And these are the pictures of the 1 can and the 1 lid and the 1 straw. There's 3 acres of property that's got a straw with a lid right there on 3 acres of property. And the fence, as far as I'm concerned, the fence, when the pieces, I've replaced several pieces of it, and the other part of it that's still down now, I'm not going to replace it because people are just knocking it down. So I'm going to leave those openings in there. The fence will be intact. I'm going to leave those openings for entrance to and from the property.
Okay. Okay, so if I understand your testimony correctly, then the fence, the portions that you wanted to repair, the sections that are, you have repaired specific sections, but specific sections, there are gaps in the fence, which
Yes.
you are using for ingress and egress.
Yes.
And so the slats themselves should all be repaired, but the gaps are on purpose. They're
Yes.
not
No,
portions. Okay.
we're not going to.
You don't want one contiguous fence?
No.
Perfect, okay.
Yeah.
Thank you.
It was ridiculous to begin with. It doesn't need a 3-foot decorative fence. It's 650 feet on Gulf Boulevard with a public sidewalk in front of it. So every time somebody has a McDonald's bag, they toss it in there. Well, I can't keep somebody on the property 24/7 to shoot people that are throwing trash on my property. It's impossible to do this. And they're sitting there watching my property like this, and it's become an impossible situation. They won't let me develop the property either. I'm in a litigation right now with them stopping me from developing this beautiful piece of property and making it the gem of St. Pete Beach. And I gave them $1 million to make this city really nice, and it literally put a target on my back. So 150 code violations in 5 years for a palm frond in my yard. Come on, guys. You know,
Thank you.
thank you.
Anything further, Mr. Luro?
I would defer to the magistrate.
Okay, thank you, Mr. Luro. Anything further from the city?
I was trying to, I can see it on there, I can't get it to open apparently with the internet
The store.
filtering. It just won't open, I can see it, that it was certified.
It was
to
sent-
the registered agent and to the property owner.
To the registered agent and to the property owner, okay.
And going back to the fence, I guess she was saying about the openings, those are actually coming up on the separate cases just because they're different parcels. So the section that I was speaking of on the first half for the repeat violation was separate from the sections of fence that she's speaking on.
Okay, and to the point, regardless of what parcel it's on, if a property owner chooses to maintain a fence but not a contiguous fence around the perimeter of the property, or even in this case, on one portion of the property, to allow for ingress and egress in different areas, is that something the city considers disrepair, or are you looking specifically for the portions that are there are in good repair?
The portions that are there that are in disrepair, not the egress, not the entrance and exit.
Right, so if I've got 100 yards on the side, but somewhere between, I've got 25 yards on this side, 25 yards on this side, and 25 yards in the middle, I don't want a fence. As long as I maintain in good repair these two 50 yards of
Right,
fence,
so-
that's okay.
Portions that are actually broken would either have to be removed or repaired.
Okay,
Yeah.
understood. But I'm not required to maintain a contiguous fence along, that's not considered disrepair, correct?
No.
Okay.
No, not the continuous fence, and would have to look into it. I think it's required to have a fence where they're at, but don't quote me on that.
Well, and that's not part and parcel of this code violation, so I am not considering that
Yeah, I'm
today.
just looking for the maintenance portion of it.
Right, I'm just looking to consider what the city considers disrepair and what was in,
Madam Special Magistrate,
yes, Mr. Dewar.
Pete Dewar, Code Enforcement Manager. Stephen, is the fence contiguous except for two openings on two separate parcels?
I'm not going to entertain that at this point, because if it's on different parcels that are part of different cases, I'm
Oh.
just hearing the fence repair on this particular case with this debris. So
Okay.
that question may come up in one of the ABC cases, but for this particular case, the testimony is that I just need to know if it's in disrepair or not, what's on the property. Thank you, Mr. Dewar, I appreciate that. Okay, so is what's on the property, so what is presently on this parcel and this property is the repeat violation. The palm fronds have been taken care of, the palm ball has been taken care of, the root ball.
Correct.
It's just, there are sections of the fence that you're saying the slats are,
There's a couple of portions of the slats that are damaged. Sections were replaced, but there's sections that are still damaged that need to be repaired. That's the only violation that remains at this time.
on this particular.
Yep, on this particular property.
Okay. Okay, anything further, Mr. LaRoe, to that?
No,
Okay.
we appreciate the privilege.
So the violations that were cited for the repeat violation are section 46-33, 1, 2, and 3. I think my previous order found 46, 33, 98, 65, 98, 66. So these are the exact same sections of code violations. I have credible testimony from the city that the certified mailing was sent to the property owner and to the property owner's registered agent. Under Chapter 162, there is nothing that says that they have to specifically receive the certified mailing. I don't write the laws, perhaps there should be. And I don't have any really counter on the registered agent. I do have testimony from the respondent and the respondent's attorney saying that she travels a lot, so even if she received the violation notice, she may not have gotten it in a timely manner. The fact of the matter is, I find that proper notice was sent. I do find that this is a repeat violation, that there were broken portions of the fence, the root ball, and the property. Under Chapter 162, no cure period is necessary. So I will find that there was a repeat violation on the property. I am going to find that the property is in substantial compliance, understanding there's some sections of fence that need to be repaired. So I'm going to find that it's in substantial compliance. I am going to issue a $25 a day fine until the fence comes into full compliance. And that is going to be from today's date until the property comes into compliance. I am going to also issue the $330 in administrative costs and any lien recording fees that might be necessary.
Thank you.
And just for purposes of the record, I am not while I appreciate the respondent and the history and the property, for purposes of my order, I am not considering any of the history of the property or the history with the donations, et cetera. I wish that I could. That's not part and parcel of this proceeding. So purposes of the record, I'm not considering that. I'm only considering the relevant evidence that was presented as of today for this particular violation.
And we appreciate the privilege and also appreciate the clarification.
Thank you, Mr. Leroux. Okay, so
Ms. Moore, I'd like to go ahead and offer her statement into the record, if I may.
and that will be accepted.
Thank you very much.
Recording fees. Okay. And moving on to new cases. Agenda item 5A, case number 20250312, City of St. Pete Beach versus SunGold LLC. I do have a question on this. A, B, and C are all the same property owners. It's all representation by Mr. Leroux, and it seems to be all the same violation. I would defer to the city attorney, but is there any value in consolidating?
I had the exact same question, and I think our code officer will explain that the parcels are all together, but they have different street addresses or different folio numbers, so I'll defer to his, but I had the same question.
Yes, ma'am. So it's the other half of the lot that we were just speaking of.
Right.
There is different parcel numbers, so there is different case numbers, but they are, I'm going to present as, if it's okay with you, present it as one whole.
Well, it's okay with me, but is it okay with Mr. Leroux?
Consent to stipulation.
Okay, so I will consolidate those three cases. So it's case number 20250312, 20250417, and 20250418. We will consolidate those three cases, and I will hear a presentation of evidence as one consolidated case.
Thank you. So this is case number 20250312, 20250417, and 20250418. Respondent is SunGold LLC. Violation address is 3855 through 3861 Gulf Boulevard. Violation description: the property is in violation of section 4633-2, enumeration, 9864A, general maintenance, 9865-4, unsightly conditions, 9866A, B, 22B, 1, 2, 24, C, and 3, residential and commercial property maintenance of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection 5/23/2025, notice of violation date at 5/28/2025, notice of violation compliance date 6/12/2025, notice of hearing dated to the property 6/17 and 7/3 of 2025. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting for case number 20250312. This is the affidavit of posting 20250417, and the affidavit of posting for 20250418. This is a section of fence that is in disrepair. Another section of fence and dead vegetation. This is one of the openings. It looked like it was a section of fence that was knocked down. As you can see, a couple of the slats there on the left side of the screen that are in disrepair. Portions of the fence that are on the ground. Picture dead vegetation and then missing slats on the fence. More dead vegetation. There's overgrown weeds in the background, just beyond the rope line there. Another section of fence that's in disrepair. And the palm fronds scattered throughout the property. And picture the overgrown weeds on the property. section of fence is in disrepair. Another section, this was on June 16th. And this debris along the sidewalk. Corrective action, property must cut the grass and weeds, the fence must be replaced, and all dead vegetation and debris must be cleaned up and disposed of. Property is not compliant, recommended fine is $250 a day starting 7/2 until compliant, plus $330 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation.
Okay, thank you, Mr. Rivera. Mr. LaRoe?
Okay. Sounds like a continuation of the same issues as before.
All the same property.
This was repaired on 6/9?
6/9. Long before 7/2.
Right. Well, I would imagine that the best approach would be to try to adopt the same ruling from...
Yes, it's all the same property, it's all one property, I did
Right.
the whole thing. So this is all one thing, one property.
And if the magistrate would entertain this, would you adopt the same fining, $25 a day from here on out?
Well, and at this point, this is not a repeat violation, so I'm not assessing any fines and fees today. My question, however, is, the last statement that was made was, I don't intend to do anything with, and I don't want to misquote, but my understanding is I'm keeping, the fence that was repaired is repaired to the extent that I'm going to repair it, and I'm not doing anything with the vegetation that's in the easement, or did I get that wrong? Has that been cleaned up?
Vegetation was all removed.
Okay, okay. So the vegetation, so as of today's date, the testimony is that the fence has been repaired to the extent that it's going to be repaired. It does not need to be replaced, and the property owner does not intend on replacing it and or taking it down. That there are ingress and egress pathways that are intentional, and that the vegetation's all been cleared. And okay, so that's where we sit on the property now. Mr. Rivera, have you had a chance to go out to see the property as of today's date?
I did, actually, as of this morning, and I was trying to pull the pictures up, but we're having
Yeah.
connectivity issues,
Welcome
so
to
we can get
Florida.
the overhead. So these are, and I'm gonna try to do my best to get it in there, but there's a section of the fence with today's date on it, where you can see the fence is still down.
Down on the ground, okay.
There's another section of fence, again, with the angles kind of hard to see.
Sure, aside from the fencing, is the vegetation, has that been cleaned up?
The vegetation has been cleaned up along the sidewalk. The fence and the overgrown grass and weeds seem to be the main concern.
Or what's still outstanding?
Yes, ma'am.
Okay. And Mr. LaRoe and your client would, 2 weeks to, and I understand the testimony is that it's been taken care of. I have photographs that were taken this morning that do show portions of the fence being down, so whomever you've hired to go repair that, you may wish.
Well, and that was done yesterday, and then probably somebody knocked it down last night. So, and once again, this is not a fence I ever wanted to build. I never wanted it on the property. It serves no purpose, and the city forced me to do it.
Yeah, and I don't have any control.
The fence down, they can tear the fence down. It's on their property, it's on city easement, and I never wanted to build it.
Yeah, I don't have any control over that, so nobody gave me the authority to do that, which is probably pretty smart. But I will say, okay, so what I'm going to do is I'm going to allow for 14 days from the date of my order to comply with the remainder of what the city is finding, the down fence portions and the overgrown weeds. So within that 14 days, whoever, from the date of my order, which may or may not get done today, depending upon how long this hearing goes, just get with the contractor, whatever you got to do to make sure. I don't, from my point of view, compliance gaps in the fence are okay if they're for ingress and egress. If there's gaps every 2 feet, that might be a problem. But so I'll do 14 days from the date of my order. This is going to be for all 3 cases. And then we will reconvene at the next hearing on August 11th, to determine if there's been compliance with the code. Hopefully I don't see you, that the property's in compliance, and we all move forward.
Thank you for the privilege, Magistrate Jello.
Thank you, Mr. Leroux, and thank you, and I will get you, I think I have your email address, so I will get you an order to that effect.
Very good. Thank you very much. Thank you, gentlemen.
Okay, so that moves A, B, and C. We are on to D. Five D, case number 202502220, City of St. Pete Beach versus, oh, I'm so sorry, Sfajunia Starkus? Mr. Rivera.
Thank you, Madam Magistrate. Stephen Rivera, City of St. Pete Beach. Case number 202502220. Respondent. I'm going to try not to mess this up also. Savinius Starkus, 1104 Pasagrow Way is the address. Violation description. Property is in violation of Section 9865-1B. Unsightly conditions 9866A, B, 2, 5, 7, 9, 22B, 1, 3E, residential and commercial property maintenance of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was 4/16/2025. Notice of violation dated 5/22/2025. Notice of violation compliance date 6/12/2025. Notice of hearing dated and posted to the property 6/24/2025. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 1104 Pasagrow Way. This is a picture of the damaged siding there at the top. Looks like on the chimney and right at the peak. And then above the right window, balcony window there. This is damaged siding and a garage door on the 11th Ave side of the property. More damaged siding. This is a damaged garage door on the Pasagrow side of the property. It's a picture of the damaged siding and the railing that was in disrepair. And another picture of the siding on the north side of the building. This is north side of the building as well. It's a picture of the overgrown vegetation. The outdoor storage, I don't know if they're studs, but it looks like planks of wood. This is in the carport area. More wood. This is on the Pasagrow side. I'm sorry, the east-facing side. More overgrown vegetation. Corrective action. Property must remove the items stored in public view, trim the palm trees back that are overgrown, repair the damaged garage doors, and repair the siding and railing. Property is not compliant. Recommended fine is $250 a day starting 6/17/2025 until compliant, plus $330 for administrative costs and any lien recording fees that may be associated with this case. The property owner has been in contact with us. We did get an email, pictures, they've been working toward compliance. So the trees have been cut back. He cut all the vegetation back. He's cleaning up the property. The siding and the garage doors haven't been repaired yet, but they are working toward compliance.
And is this a commercial property?
No, ma'am.
Okay, it's a residential property.
Residential.
For the siding and the garage doors, does that require permitting?
Yes, I know the garage doors will. I'm not 100% about the siding, but I know the garage doors will require.
And do you know if a permit has been applied for?
Not to my knowledge, no.
Okay. Okay, thank you, Mr. Rivera. Anyone here on behalf of the property owner? If you could please come and state your name for the record.
Yes, hello. I am Svajūnas Starkus, owner of the property, 1104 Pasagrow Way. So situation is that that notice I received only 2 weeks ago, I didn't receive those others before. You left only on the door this one, and I came, yeah, so I found the first time only that one, and I came next day right away to meet. I met Jennifer Hansch. So I started sending pictures that I'm cleaning up. You know, all that's the building stuff, it was moved from the garages because, you know, after those hurricanes, I was working over there cleaning up. And now, garage door and siding, especially with siding, it is not that easy, not that simple, because about 1/4 of the siding it's gone completely. And damages, water came through the roof, all sliding doors, and everything is completely damaged inside the house. And the house is very huge, 6,000 square feet. So I'm dealing with the insurance, but as you know, it's not easy. It's still not done, and I don't know when I'm gonna end with them. So there is not only some small repairs with that siding. I practically, because what is holding still on it, it's almost practically lost, because after those winds and water came through, so I have to do, I have to replace practically all of the windows and sliding doors. I have to do waterproof, and new siding, it has to go completely on all house, because there is no other way how to do those repairs. But it's not like you know, a few $1,000 job. It is like hundreds of thousands is gonna cost for me. So I'm dealing with insurance, but I still didn't finish with them. So if it is, and like outside, I cleaned up everything, you saw probably already, and so I don't know. I'm just asking some time somehow to finish with insurance, or if I have to do something, but it's really expensive. It is impossible to handle. So I don't.
Where are you, Mr. Starkus, in the insurance process? You've already made the claim, you have an
I made the
inspection?
claims, 2 claims after those 2 hurricanes.
For Hilton and Helene.
They were
Milton and
sending
Helene.
some inspectors, but 3 months, they still didn't finish after 3 months. So I hired private adjusters. They were dealing like for 6 or 7 months with them. And finally, they informed me like, because I contacted with them again after this, receiving this notice. I said, you guys, you have to do something to finalize, or I don't know what to do. So they said that they just can't do anything because insurance not working with them, not transferring, and I have to hire a lawyer to start working that way. And you know, they just walked away. A few days ago, I received notice that they are okay to leave it, and I have to hire, without like paying for them something, and I have to hire a lawyer. I contacted with insurance again, so I will see how it goes. If I have to hire the lawyer, I have to hire. So
Okay.
that's where I am. And
Yeah, so I mean, the reason I asked the question is I was trying to figure out how much longer you would need. It does sound like there's a lot more extensive damage, and just repairing the siding isn't going to do anything, because
No,
if you
it's-
repair it now,
the roof also will.
you'll have to rip it all up. Whatever you repair now just to cure this issue, you'll have to rip it all up to do the larger repair
That's
of
right.
the
because
damage on the
There is no
inside.
way how to replace those that siding, because it's, you know, it's more. First of all, windows doors supposed to be replaced. Roof.
The garage doors and the
only-
doors
Yes, garage
and the
doors
windows.
only done siding. So.
Okay. Okay, and so at this point, you've reached out to the insurance company to work with them directly to
Yes.
see if you need to hire a lawyer, or if
Yes,
you
I
can
hope
work.
it's gonna work without that, but if not, so.
Okay.
We'll see.
Okay, so at this point, anything else from the city?
No, ma'am, he is cleaning up when he did get the notice on the door, I mean, in his favor, the trees were getting trimmed within a day or 2 after that, so he is trying to work toward compliance, I do believe. Sean.
Right, everything that you can do that's not otherwise reliant on somebody else to do their job, you've
Right.
kind of complied with. I do have some concerns about, I mean, honestly, there's nothing really you're gonna be able to do. My concerns are, we've got hurricane season well underway at this point. You've got exposed siding, but you're no different than anyone else that went through the last 2 hurricanes as well. So, I'm gonna do this. I am going to find that there is a violation of the stated code section, but I'm going to give you 60 days to work towards compliance. And for me, compliance is gonna look like a building permit application, but you might not be able to do that until you get information from your insurance company and to figure out where you're gonna go. So at this point, I'm giving you 60 days, 2 months to figure out what direction that you can go in and to make headway on whichever way that looks like. And then we will meet back here. That's actually gonna probably put us into September, October. Jenny, do you know when the October hearing is?
October 13th.
Okay. Yeah, let's go ahead and set a status hearing for October 13th for that hearing. And then we'll figure out how far you've gotten within that time period, and what the next course of action is. If you've made good faith efforts, then we'll look to continue it and see if there's no light at the end of the tunnel. We'll figure it out from there, so.
Okay.
Thank you, Mr. Sarkis, and make sure we have your contact information so I can send you a copy of the order.
I left.
All right, thank you.
Okay, thank you.
Thank you.
Madam Special Magistrate?
Yes.
A respondent is here who is experiencing difficulty with his eyesight and has requested his case be heard because the light is impacting him.
Certainly, what case number is that?
Q, case number 2024-0504.
All right, does the city have any objection to hearing that case out of turn?
No, Your Honor.
Okay. All right, then we will move on to agenda item 5Q, case number 20240504, City of St. Pete Beach versus Jeffrey Myers.
Madam Special Magistrate, that was me going through the 600 pages of
I think
documents.
it's 588
We're there.
is where it begins.
Thank you. Case number 2024-0504, respondent Jeffrey Myers, violation address 191 73rd Avenue. Violation description, the property is in violation of section 46-142A4 and B4, pattern of nuisance activity of the chronic nuisance property code for the City of St. Pete Beach. Special Magistrate ordered Order 2021-0494 from 1/12/2022, violation of Section 9866, residential and commercial property maintenance. Special Magistrate Order 2023-0536 from 11/14/2023, violation of Section 46-33, enumeration, and 9865, unsightly condition. Initial inspection for this specific case is 4/4/2025, notice of nuisance dated 6/23/2025, notices of hearing dated and posted on the property 6/23/2025. These photographs are an accurate description of what was observed on the dates they were taken. This was actually posted by Officer Rokteshel, and she's here to testify in case you need to hear from her concerning any of the postings or pictures. So this is a close-up, and this is out further from the property, from the fence that it was posted on. This is the finding of fact that was submitted as part of our evidence. And as you can see here on this first page, it shows that the section in violation was 98-66. And the respondent was given until January 20th, 2022 to bring the property into full compliance with the city code. November 2023, this order was found, the respondent was found to be in violation of section 613, 46-33, and 9865 of the Code of Ordinances, and was given 30 days from the date of this order, or by Thursday, December 14, 2023, to remove the portable storage unit, remove the remaining debris and furniture, and remove or address the issues with the trailers, RV, and clothing. These photographs, again, are a true and accurate representation as to what you are observing on the dates they were taken. As you can see, this was in 2021, on September 23rd, 2021. So we went from 2021 to now 2022, and you can see the change, the progressive change of that property becoming more and more of a nuisance property and an eyesore in the community. And these photographs are 2025. I'd like to introduce pictures taken this morning, and these pictures speak volumes. As we know, a picture is worth 1,000 words, so there's not much needed as far as narrative is concerned. But you can clearly see that the property, I will say this on behalf of the owner. Could we go to the overhead, please? I think they've been furiously trying to clean this property up ever since they were notified. I spoke to the gentleman in the picture. Could you go back to the monitor, please? If you notice there's a gentleman there, I spoke to him, and like I said, they have been trying to bring the property to some semblance of order. There's much work still to be done. Go back to the overhead, please. What you're looking at in the upper balcony of the property, those are shoes that have been laid out for some odd reason. I couldn't tell you why they were there, but there were over 30 or 40 shoes placed on the balcony. That vehicle remains, and these pictures, again, are true and accurate, and they were taken today. That vehicle does not have, vehicle has an expired tag on it. There is evidence that in this area right there, they have cleaned that area up. There's a dumpster being filled with materials. This is the garage that they're unable to close because it's so filled. The materials, debris, they're spilling out of the garage. More debris. A close-up of one of the trailers, indicative of no license tag, license plate. Trailer showing the wheels are deflated. And that's another photograph of the garage that's filled to the brim. Madam Special Magistrate, we're here requesting that you declare this property a nuisance and the city be allowed to abate the nuisance.
Madam Magistrate, may I ask Mr. Dewar a few questions?
Absolutely.
This is, for the benefit of all watching, this is, I believe, the first time that the city has moved forward with the chronic nuisance section of its code of ordinances. And I know that there were recently some amendments that were made to that as well. Mr. Dewar and I, we did have a conversation before this morning's meeting, and I want to make sure that that we have in the record, I believe, what's needed.
So before you go on, Ms. Zubrick, are we moving underneath the chronic nuisance property code or the nuisance abatement section of the city's code? Because those are two separate sections, and the chronic nuisance has to do with criminal activity.
The question you're asking is one that I raised as well, so
Okay.
I'm glad that we can clarify this for you. As I understand it, it is the city's intent to proceed under the chronic nuisance section, and that would be, that part of your code begins in 46-141.
Okay.
Therein, in section 46-142, the definition of nuisance has been defined by 33 different ways, including the criminal activity that you've referenced. And Mr. Dewar, do you want to specify for the record your testimony as to why you believe that the evidence you're presenting is nuisance activity?
Yes, ma'am. Could we go to the overhead, please? Madam Special Magistrate, as was just mentioned, section 46-142, pattern of nuisance activity includes, as you just heard, several sections to it, subsections. Nuisance activity means any activities relating to the following violations whenever engaged in by the property owner, agent, tenant, or invitee of the property owner, agent, or tenant.
And the specific sections that you believe fall under the definition of nuisance activity based on your testimony and your evidence?
A junk, wrecked, abandoned property is defined in Chapter 46 of this code. 33, failure to correct violations on or before the date specified in the notice of violation issued in accordance with Section 22-276 of this code. B, pattern of nuisance activity. Real property shall be deemed to exhibit a pattern of nuisance activity if before failure to correct code violations by the time ordered by the special magistrate in any order entered pursuant to Section 22-277 of this code.
So is it the city's position that, that this property is declared to be a chronic nuisance?
Yes,
And
based
was-
on this subsection cited.
And was notice provided to the property owner to that effect?
Notice was provided.
Can you describe the notice that was provided? Can you,
The notice that was provided was notice of nuisance on that property. I'm going to get that notice.
and while he's getting that, if I may,
Go
the
to the
property
overhead.
owner is present today, and staff has had some ongoing communication with him in view of the weather. We appreciate him being here today, and your approval to provide accommodations to him for his visual
There's a
concern.
notice of nuisance that was sent to Mr. Myers June 23rd, 2025. That's on the under the overhead.
So, Your Honor, I think that based on the new changes that were made to the ordinance, I believe that we would be asking under Section 46-145, paren E, that you review the record and the evidence upon which the city has based its declaration of chronic nuisance activity or notice of the violation regarding the action plan. And I don't recall, Mr. Dwar, if you provided your testimony regarding the status of the action plan?
No action plan was received by the city within the time period specified in the order, in the notice. Could we go back to the notice, please? Paragraph 2, you're hereby notified that unless the condition above is remedied so as to abate the nuisance within 14 days from the date hereof, the city of St. Pete Beach will proceed to remedy this condition, and the cost of the work to remedy the condition, advertising costs, administrative costs, and other expenses will be imposed as a lien on the property described. To remedy the condition causing the nuisance, the following must occur. The property owner is required to provide the city with a written action plan outlining the specific measures that you will take to eliminate the recurrence of nuisance activities on the property. The action plan must be provided to the city no later than 15 days from the date of the declaration notice of chronic nuisance property on 6/23/2025. Failure to provide the city with a timely written action plan shall be a violation of this article. An entry of a chronic nuisance service order by the special magistrate. Costs of any chronic nuisance services provided by the city to a property that has been declared to be a nuisance or a chronic nuisance may be levied against the property as a non-ad valorem assessment superior to all other private rights, interests, liens, encumbrances, titles, and claims upon the property, and equal in rank and dignity with a lien for ad valorem taxes, and all unpaid assessments may be certified to the tax collector for collection pursuant to the uniform method provided in Florida statute 197.3632.
So if I heard correctly, then your testimony is that there's no formal plan that's been provided. However, you have had ongoing conversation, and I think your testimony was also that there has been some improvement. Is that correct? Or
I am
can you
going-
clarify or testify as to the interaction that you've had?
I've had several interactions with Mr. Myers, including today, and he, as I've mentioned earlier, has an issue with his eyesight, and part of that difficulty is, I think, what has created the situation at his property. Mr. Myers has been at his wit's end trying to clean the property up, but unable to do so, and this property has been an eyesore for the last several years. Because of that, I think the city is left no other recourse but to try to get an abatement order by the special magistrate so that the city can enter the property to clean it up.
So that begs the question, why isn't the city looking to get an abatement order underneath the nuisance abatement? I've heard at least one case with Mr. Meyer with regards to this property, and I understand his visual capabilities and lack thereof, and the issues he's had trying to get people to help him clear the property and whatnot. But why is the city seeking to look at this as a chronic nuisance abatement instead of going underneath the nuisance abatement code and seeking to enter the property to clean it up? You have two different codes here. So what I was provided with yesterday from the city is a copy of the newly revised ordinance from the City Commission with the nuisance abatement code and the chronic nuisance code. The city, is my understanding from the clarification from Ms. Superick, is that the city is choosing to move under the chronic nuisance abatement, and I'm certain, I can certainly analyze it underneath that section of the code. My question is, you know, the city seems to be seeking recourse and going onto the property and abating the nuisance, but the chronic nuisance abatement code seems to be not only seeking that, but a lien. I'm not 100% certain that it will have the effect that the code references based on some case law, but other than that, I guess my simple question is, why are we looking under chronic nuisance abatement instead of nuisance abatement?
There are two liens on that property, and
Sure.
obviously with those two liens, it means nothing. The neighbors are upset over the fact that it's
Sure.
a continued eyesore, so
But how come the city isn't seeking just to go under the nuisance abatement code and go clean it up?
that's a good question, Madam Special Magistrate.
We felt that the authority was a little bit crystal clear under section 46-147, that it was just a little bit stronger,
Okay.
Yes.
because there is this pattern that has been established by testimony and the evidence for the need to abate.
Okay, anything further from the city?
Not at this time, ma'am.
I don't see in your property, in the chronic nuisance abatement section, that the property owner has the ability to challenge this at all. Under my reading of the code, and it gives me pause, but under my reading of the code, the notice and an opportunity to be heard is based on the notice being the notice of the chronic nuisance, referencing chapters 46, and the opportunity to be heard being the submission of a chronic nuisance abatement plan. Ms. Subrick, is that your reading of the code as well?
I believe there was the opportunity for the property owner to request a hearing. I think there may have been a modification to that to allow the city to come forward as well. Regardless, the property owner is present, and based on the information that's been provided, I think that I'm looking at 46-145. A request for a hearing may be filed with the city.
Sure, and I'm looking under the 46-145 where it's just been changed to hearing, and under subsection E, it says, upon the request of the code enforcement officer, the city shall schedule a hearing before the special magistrate. The hearing shall be limited to the review of the record evidence upon which the city based the declaration of chronic nuisance property or notice of violation regarding the action plan. And all I'm supposed to do is review the record evidence that the city made its determination of and either accept it or reject it, the declaration of the chronic nuisance of the property.
So I would concur that the language, again, this section of the ordinance has recently been amended, and this is really our first use of it. However, the property owner is present in utmost respect of his due process rights. He is present today and can provide you with his version of why he may not be, believe himself to be the chronic nuisance.
My concern is the code directs me to limit my determination based solely on the city's record evidence. So I guess my question would be if the city has no objection to the property owner presenting testimony to be considered as part of the record that I am allowed to consider in determination of whether the property is a chronic nuisance, then
We would agree to that.
okay. Then anything further from the city, Mr.
No,
Dewar?
ma'am. I was just wondering if failure to provide the city with a timely written action plan, which is a violation pursuant to this article, wouldn't that be sufficient enough to allay your fears of him not being able to have a response?
And I don't necessarily disagree. You're given notice and an opportunity to be heard. And your opportunity to be heard might be the action plan. I have some hesitation in the way, regardless, I don't get to comment on how the code is written or determine whether or not it's sufficient or not. I just have hesitation with considering this necessarily a chronic nuisance when you've given me 2 dates. I don't know if that's necessarily a pattern. There's now 3, so that might be a pattern. They're all within 2-4 years. So I'm not, obviously I'm not making a determination right now. I'm just inquiring as to, the way I read the code is, it doesn't matter what Mr. Meyer says to me today because he had, pursuant to the notice, which I've had an opportunity to review against the code, it would appear from my cursory review that the notice is sufficient to meet with the chronic nuisance ordinance, in that it's giving him 15 days from the date of the declaration of the notice of the chronic nuisance to provide an action plan. But this is also saying this is a notice of nuisance, not a declaration of a chronic nuisance. Well, and it does say that you found and determined that a nuisance has occurred.
Are you also taking into account pattern of nuisance activity to include failure to correct the code violations?
I'm not even there yet. I'm
Okay.
literally just talking about the notice and whether it meets with, so your question to me was, do I need to even entertain Mr. Meyer's testimony? That's my question too.
Got it.
My understanding, if we are talking about due process rights, it's a notice and opportunity to be heard in an administrative hearing such as this. Is notice sufficient? I've looked at it. It appears that notice is sufficient to meet with the city's amended code. Is the opportunity to be heard, is submitting an action plan enough? I don't necessarily think so. I think that you're submitting an action plan and you're not giving the opportunity to object to the fact that you've determined that it's a chronic nuisance. So I'm willing to at this point entertain Mr. Meyer's testimony if he has an objection to the property being considered a chronic nuisance, because I think he has the due process right to do that. So that may not be included in the code, and if this is appealed, that might be something that gets overturned on appeal. But I think according to basic due process rights, I don't think that's sufficient enough opportunity to be heard, as it's not really, there's no information here that allows for him to object to the determination. It just subjects him to the chronic nuisance and then says, give us an action plan on how you're going to do that. Perhaps maybe that means he could have submitted an action plan that says, I don't think it's a chronic nuisance, have a nice day. So just to make sure everyone gets there, we'll call it a day in court. I would like an opportunity to hear from Mr. Myers if he so chooses to speak on his behalf. And I apologize, Mr. Myers, you've had to wait so long, but we'll try and get through this.
My name is Jeffrey Myers.
All right, and Mr. Myers, you understand that the city is seeking to have your property determined to be a chronic nuisance, and if it is determined to be a chronic nuisance, they're seeking to enter your property to clean it up. And then after cleaning it up, whatever costs it takes them to clean it up, they are going to assert a lien on your property for that. Do you understand that?
I do.
Okay. And do you have anything to say in defense of that?
I missed a court date a long time ago, and I spoke to him right that day, and I thought I was going to be receiving something in writing, and he just encouraged me to continue cleaning everything up. And I've had a lot of ups and downs with that. I had a lot of problems with that. I have a lot of people that I trusted, and they weren't doing what they said they were doing, but then I didn't hear for a long time from anybody. I had a realtor because I was looking at it. I'm looking to sell the property. I'm looking to be able to move closer to where I came from. I came here because I was ill, and I went to Moffett and got treatment, and I lost my eyesight in the process, and it was COVID, and I bought this property. I'm trying to adjust to being blind. I hoped that transplant surgery would have given me some eyesight back. It didn't. I rejected 2 times the surgery. It took 5 years to get my Social Security. I was awarded that in May. Before any of these notices in June, I already had a dumpster at the property and was already trying to get everything taken care of. We had 5 feet of water during the hurricanes this year go through the lower area of the house to the garage area. All that stuff has to go. In the last, since they talked to me and I was aware of this order thing, I think they've gotten rid of a lot of the garbage. Substantially, 2 huge dumpsters of stuff that have been removed, and they're continuing to work every day. The trailers are scheduled to be removed. The RV is a little bit more challenging because I think the flood destroyed it. It won't start anymore. It only had 30,000 miles on it, even though it was an older one. But I think it has to be taken to a junkyard. I'm not opposing any of that, I just don't understand why it's happening now. I could have used this help. I think if I'm hearing you right, you would come in and help me get rid of everything and just charge me for it. That would have been great, like a year ago, which should have happened. Because I really need to be able to get on with selling the property and getting closer to where I can have friends. All my family's deceased now, but I do have friends. I was in the Daytona Beach area for 20 years. I was respected there before I lost my eyesight and everything. I have friends there that can help take care of me. I don't think I've ever been resistant to any help or anything. I don't know.
It's just okay.
A lot of what I'm hearing today I don't even understand.
Okay, and I want to make sure that you do understand it. So at least from my involvement and from what the evidence that the city has presented me with is at least in 2022 and 2024, there were code enforcement violations against the property for it being just a lot of debris, junk, that kind of things, or just outdoor storage, that kind of stuff. I've seen the pictures. I was here for at least one of those hearings, and gave you a certain amount of time based on your testimony to clear all that out. And I understand that you had made efforts to do that. And I understand too your testimony in 2024 about not being able to do that because the people that you said were going to help you ended up not helping you, or there were not groups. And you did have some issues in between there where you were going through personal things. So I can understand that, where you're sitting. Mm-hmm. So I think the city at this point, and I don't want to put words in the city's mouth, but my understanding from the testimony is that issuing a code citation isn't enough because that comes with a financial penalty to try and get you to clean up the property, but it doesn't actually clean up the property, which is really what the city is seeking, is compliance with the code.
Isn't that what I've done over the last 10 days or so?
So yes, but what the city is saying is it's taken since 2022 to get to this point where you're trying to do it. And I understand the hurdles you've had.
It started before the even I got a notice. I mean, I've been actively trying this, being able to afford the dumpsters and all that.
Right.
I have an insurance claim that is still in process. I've decided to simply accept the claim. I had they had me do estimates on it. They wanted like $28,000 to clean the property up. They're only giving me $10,000. I'm just accepting it. I'm going to use my money I got from Social Security to just make sure it's all cleaned up.
So, and here's where the ramifications of this particular thing. So it's no longer just a code enforcement violation. Now the city is moving forward with a chronic nuisance violation. And what that means is twofold. If I determine that I agree with the city's representation that it's a chronic nuisance, then the city will have the ability to go onto the property and clean it and then charge you back for it, but it will be a lien on your home. So if you're trying to sell the property, that's going to be an encumbrance to selling it.
I don't understand why I wouldn't just be satisfied at the time I said, I don't.
It might be satisfied at the time of the sale, and that's fine. I mean, the same as your other code enforcement liens, right? Once the property's cleaned up too, that's going to satisfy your other code enforcement
I'm
issues.
not aware of any other liens on my property,
Well, you do have 2 outstanding code enforcement cases
right?
that had daily running fines on them. Is that correct, Mr. Dewar? Yes. So those daily running fines are still going until the property comes into compliance. And again, that's what the city is seeking. So
I wasn't aware of any of this. So why, you don't notify me, or?
I did notify you. I sent an order to your home, and I've spoken with you about this before.
We were supposed to meet I had the date down being Tuesday, and I think court was on Monday. And I thought I was going to get called right back again, and then I never heard from nothing. And then when we went to sell, I went to ask a realtor to help me with it, and I told him about all this. He came over and talked to people here, and he just said I just needed to get everything, continue just getting it cleaned up, and I've been doing that.
And there's a way for the city to work with you on reduction of those fines, and you can talk to your realtor.
I'm aware of what they are.
And I am not either. And the only reason I am privy to that information is because, 1, the record evidence that Mr. Dewar just presented, and 2, I was here for some of those hearings. So I, from my point of view, what I just need you to understand is that if I find that it's a chronic nuisance, then again, you'll get the help that you need because the city will go in and make the property compliant.
Hopefully it would be done before that.
But it may very well be, and if it is done before that, then the city won't have to go in and abate too much, right? And so they may not have to put any lien on your property because it might be satisfied on your own. But there will be that type of a declaration out there. So I just need you to understand that. And so you're telling me that, and I've heard this before from you, that you have been trying to clean up the property, and I've seen, based on the pictures that Mr. Dewar just recently put up, there has been substantial cleanup, but there's a lot more to go, right?
There's a lot more. I was
And so,
this morning about.
so in your eyes, you think that you can get it all cleaned up. How long do you think that would take?
It should have been done yesterday. I have the funds now, though, too. Funds were a big issue for me. I didn't, like I said, 5 years I've been fighting for myself. I finally had a hearing. County offer gave me a hearing, and the judge ruled in my favor based on the initial documentation that was given to my first application 5 years ago. So I received the retro pay on that, and so now I'm actually in a position where I was able to pay for all these things to start to happen.
Okay.
And
So what do you think, how long do you think it would take you for?
hire more people other than the people that were working on it, because pretty much everything just has to go into the trash.
Okay.
I'm aware of that. 5 feet of water into the downstairs. I was fighting with the insurance company because, I mean, some of the stuff in the downstairs there is still filled water, flood water. It's just not even safe, and they just, I heard somebody else here say they had like all this time, or my insurance company, which is the National Flood Insurance Company, they were without even taking phone calls for almost 3 months.
Yeah.
They wouldn't even take our phone calls. And then they come in, they give me this offer back, and I don't even care at this point. I'll use whatever monies I have to get this cleaned up.
So if you have the funds now and you have people there, how long do you think it would take you to clear the property?
I want to say within a week to 2 weeks. It
A week to
shouldn't
2
take much more. I mean, I need help because I don't. You looked at it this morning, right? They got a lot of it gone.
Yep.
The rest of it just has to go into the dumpsters.
Okay. Okay.
It shouldn't help. It shouldn't be that hard for them. For them just. It's literally just
To
moving
haul
it.
it away.
Right, just hauling it away.
Right. Okay.
And there's already a schedule what they're doing with the trailers and the RV. They want to move it to this place to have it stored. I don't think it should be. I think it needs to.
You just want to junk that too. Okay. Okay. Well, that gives us then a time frame. All right. Anything else, Mr. Meyer, you would like to say on your behalf?
It's just, I wish that people were, I wish you guys communicated more to us in a form of the mail or something, that we were more aware of what was happening. I kind of thought no news was good news, and I didn't hear nothing from nobody for so long.
I can understand that, Mr. Myers. I will say that the process that we have in place for code enforcement has been around for a while. We're subject to what the state allows us to do, and, you know, there's...
I'm right next door, you can just come.
I know. I drive by your house when I leave here, so I know. I will say this, you know, I think the city of St. Pete, it means nothing to this case, and it's not really part of the record. I think the city of St. Pete Beach has done a lot of communicating. I think you've done a good job communicating with them, but they are a city of thousands of people, and they can't cater to every single person. So, okay, thank you, Mr. Myers. I really appreciate your coming here today, and I appreciate the information that you've given me and that I can consider in making my determination. And if you have nothing else to say, you can go ahead and be seated, and I'll go ahead and, if the city has nothing else.
Again, the city's primary goal in this situation is to bring the property into compliance. It has been quite a while that it's been subject to these various code violations and being out of compliance. I think the city is hopeful to hear that he can have it fixed and come into compliance within a very short period of time. There is no written plan to bring it into compliance. We would like to have some type of certainty maybe from him within whatever time period you offer for a compliance date, so that there would be perhaps periodic checks with the city as far as how it's coming along, and then report back to you at a particular time to let you know whether or not it has been complied, come into compliance. Based on the evidence that has been presented to you, we would also request that perhaps you make partial findings of fact.
Well, I'm going to comply with sections 46-146 and 46-147 of the Chronic Nuisance Abatement Code, which deal with entry of the chronic nuisance service order as well as abatement by the city. So in with my order, I will have to establish findings of fact that a pattern of nuisance. Well, we'll go through it, and I'll do it on the record, and I'll also put it in writing. That way the city has it. So section 46-146 of the Chronic Nuisance Abatement Code says that if the timely request of the hearing has, well, let's see, blah, blah, blah. The special magistrate shall enter a chronic nuisance service order if I uphold the declaration of the chronic nuisance property or determine after the hearing there's been a failure to provide or implement an adequate action plan. At this point, I find that the notice of nuisance provided to the property owner by the city meets and comports with the Chronic Nuisance Abatement Code and with sufficient notice. I'm also making a determination that the property owner received such notice and had an opportunity to be heard at a public hearing. I do make a determination that based on the record evidence presented by the city, which is included with the dates of 1/11/2024 and 1/12/2022, going back several years, and not having found that those final magistrate orders have been complied with. Though the property owner is looking to bring the property in compliance, I do find that the evidence does meet with the standards in the code and that there is a chronic nuisance established by the city at this property. I will authorize the city to provide chronic nuisance services to the property. However, I will not allow the city to do so until after 14 days from the date of a chronic nuisance order, as that is the time that the property owner said it was sufficient enough for him to clean it up. I would like to allow him to get as much done on his own as he can without allowing the government to enter his private property and do so. I am going to authorize the city to bill the costs of any chronic nuisance services to the owner of the chronic nuisance property, and I will go ahead and mail a copy of the chronic nuisance service order by certified mail, return receipt required, and first class mail to any mortgagee of record. And I will go ahead and have that, unless the city would like to record the order, I can certainly have my office record the order in the public record. It does say provide for the recording, so my order can just say that the city will be directed to record the order.
If you'd like to record it, it would be fine.
Okay, I will provide for the recording of a certified copy of the chronic nuisance service order in the public records, and I will provide in my order for continuing jurisdiction over the chronic nuisance property for a period not to exceed 1 year after the entry of an order. After 1 year after the entry of the order, my jurisdiction will cease if there has been no nuisance activities. If there has been nuisance activities within that 1 year period, I will retain jurisdiction, and extension of that order may be granted pursuant to the city's code. Again, the city does have the ability to abate after 14 days from the date of my order, and to assess the cost, the reasonable costs associated with that. And I will make sure that I get that all put in a written order, and Mr. Myers, you will be provided with a copy of that. If you have any questions about that order, please contact the city, okay? Okay. 14 days appropriate, or? Okay, 14 days is, okay, that sounds good. All right, then we are concluded on that case. And Mr. Myers, if you have any questions, like I said, please contact the city.
Okay.
All right, that was Q, correct? 14 days.
I think we are on E.
Yep.
Okay.
Okay. Moving on to 5E. You get to go back 588 slides, I think, or something like that. And just to tie up the loophole on the chronic nuisance case, if I will be recording the order, once I fill out the order, I will just need the city clerk's office to certify the order before I can record it.
We'll take care of that.
Okay,
Thank you.
Moving on to 5E, case number 202500279. City of St. Pete Beach versus Coconut Inn LLC.
Thank you, Madam Magistrate. Stephen Rivera again, City of St. Pete Beach Code Enforcement. Case number 202500279, respondents Coconut Inn LLC. Violation address is 113 11th Ave. Violation description: the property is in violation of section 44.5A 1 and 2, B 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Standards for existing beachfront lighting of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection was 5/9/2025. Notice of violation dated 5/15/2025. Notice of violation compliance date 6/16/2025. Notice of hearing dated and posted to the property 6/25/2025. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 113th 11th Ave. These are the balcony lights that were non-compliant, or upstairs lighting, second level. That's a little bit of a zoomed-in photo there. And the follow-up picture, same lights. Corrective action: property must replace the lights with turtle-friendly lighting or turn the lights off from May 1st through October 31st. Property is not compliant. Recommended fine is $250 a day starting 5/27/2025 until compliant, plus $330 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation.
Okay, thank you. Anyone here on behalf of Coconut Inn LLC? If you could please come and state your name and affiliation with the LLC for the record.
Hi, Maggie LeBlanc. I'm the owner of Coconut Inn LLC, managing partner of the LLC. I am really embarrassed because I am thought I was super aware of all of the sea turtle, things to protect the sea turtles. In the 16 years that I've had the property, we've never been alerted to the fact, and it really just never occurred to me. I don't know why. I have no excuse for not doing it in a timely fashion, other than the sconces that we have there are 16 years old. We had a hard time finding the correct light bulbs. We have since found them. And so what we did was, well, we have a timer on it, so we figured if it goes off at sunset, but then that didn't seem to work. It was like a series of things that happened, and then we unscrewed the light bulbs. As for the guest rooms, it didn't even occur to me that the guest rooms needed to be, the lights needed to be off. So we tried communicating to the guests about that. I did come here after the second notice of the violation, and Jen gave me the little decals, which we now put inside of all of the guest rooms that are there on the corner, so that the guests are aware, because what was happening, we were communicating it, but then the guest was forgetting or staff wasn't communicating it properly, whatever the case may be. But the bottom line is we are now in compliance, and we have those light bulbs being delivered probably in the next few days. And we should be in full compliance. We are now temporarily, but I do have other measures.
Just like turning the lights off now instead of having them
Yeah,
replaced.
correct, but that's not foolproof, so we really do need those light bulbs, because those sconces were so old. It was, and they're very specific, and I can't just replace those 3 because I have 30 of them matching on the property.
Okay.
So we didn't want to have to replace all 30 sconces. So we did find the correct light bulb finally, and so that'll be installed.
Do you have a time frame on when all the installation might be completed?
Within the next week, but like I said, we are already in compliance because we did unscrew all of those light bulbs and put the decals in the rooms. That has really helped, and the brochures that Jen gave me as well, which is good for the guests. It gives them a better understanding about how important it is to do that.
Okay, and then keep in mind too, if your guests choose not to listen to that, you'd still be subject to future code enforcement on that.
Yeah,
So
that's the scary part.
there might be window tinting or something that you can do. I'm not super familiar, and don't
Okay.
take my advice. I am just the magistrate, but there might be
Yeah.
something else that you can do.
Okay, yeah, that's a good point, thank you.
All right, anything else that you'd like to say in your defense?
No, that's it.
Okay.
Just embarrassed by the whole thing.
Well, thank you very much, Ms. LeBlanc. Anything else from the city?
No, ma'am.
Okay, so I am going to find that there was a violation of the stated code sections. I'm going to allow for 14 days from the date of my order to come into full compliance, understanding you're in compliance now, but full compliance with whatever you need to do with the light bulbs, et cetera. And then if the property doesn't come into compliance in the 14 days, then we'll see you back here in August. If it does, I hope to not see you, and I hope to not see you again. And I will get you an order to that effect. Just make sure that we have your contact information on the sign-in sheet. All right, thank you very much. Okay, that was E. Moving on to 5F, case number 20250275, City of St. Pete Beach versus Hurricane Lounge, Inc.
Thank you, Madam Magistrate. Steve Rivera again, City of St. Pete Beach Code Enforcement. Case number 20250275, respondents Hurricane Lounge Incorporated. Violation address is 809 Gulf Way. Violations description: the property is in violation of section 44.5A 1 and 2, B1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Standards for existing beachfront lighting of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection was 5/9/2025. Notice of violation dated 5/15/2025. Notice of violation compliance date 6/16/2025. Notice of hearing dated and posted to the property 6/25/2025. Following is a true and accurate representation of what I have witnessed. This is the affidavit of posting at 809 Gulf Way. This was from my initial inspection, May 9th, 2025. Shows the lights at the top there, upper half of the building. It's a picture highlighting the lights that were in violation. This was on June 24th. This was a follow-up inspection. It looked like there was some uplighting that was hitting the roof of the lounge. And then there was a stairwell that was also noticed that was in violation. Corrective action, property must replace the lights with turtle-friendly lighting or turn the lights off from May 1st through October 31st. Property is not compliant, recommended fine is $250 a day starting 5/27/2025 until compliant, plus $330 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation.
All right, thank you, Mr. Rivera. Anyone here on behalf of Hurricane Lounge, Inc.? If you could please state your name and affiliation with the corporation for the record.
Rick Falkenstein, 809 Gulf Way, St. Pete Beach, 33706, president, owner. We have done a lot of mediation using orange tint. The one roof line that was added, the orange tint, and we turned off multiple lights. Staircase, we've added some orange tint to the lights. And if we need to do more, we'll do more.
Okay, so at this point, you find that you are compliant. Have you contacted the city to come out and look to make sure that you're compliant with the turtle lighting code?
I spoke with Stephen last week and told him what was done.
Okay.
And then before that, I've been in contact with the city probably 3 times. Jen, and then Jen would transfer it to Stephen.
Okay. Okay. And then, and when did you do the orange tints? Was that before you, well, I guess the
Well,
notice?
before I went on vacation,
Okay.
there was some done. When I came back, we completed it.
And when was that date? If you recall.
I want to say after
June, July?
it was July.
July, okay. All right. Okay, anything else that you'd like to say?
If I'm not in compliant, let me know and I'll get more orange tint.
Okay. All right, sounds good. Anything else, Mr. Rivera?
No, ma'am.
Okay, so I'm going to give you, understanding that you feel that you're in compliance, I want to make sure that the city goes out and that you are in fact in compliance. So same as the last respondent, I'm going to give you 14 days from the date of my order to come in full compliance. I am going to find that you were in violation of the stated code sections, but you did make efforts. So I'm going to give 14 days from the date of my order to come into full compliance. Just get with the city and make sure that the orange tinting is enough and that everything is fully compliant with the turtle lighting code. If you do that within 14 days and everything's good, then I won't see you here. If you don't, then unfortunately I'll see you here in August and we'll talk about if we need to impose a fine or anything like that.
I've ordered more orange tint, so
Okay.
should be here Wednesday.
All right, sounds good. Just make sure I have your contact information so I can get an order to that effect sent to you. All right, moving on to 5G. Case number 20250069, City of St. Pete Beach versus Annie Nguyen and Timmy Trong.
Thank you, Madam Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement Case Number 2025-0069. Respondent is Andy Nugent and Jimmy C. Trong. Violation address is 205 55th Avenue. Violation description: the property is in violation of Section 46-33 enumeration 1A, 2, and 3. 98-64 general maintenance A, 98-65 unsightly conditions 1A, B, and 4, 98-66 residential and commercial property maintenance A, B, 20, C, 2, and 3 of the Code of Ordinances of City of St. Pete Beach. Case summary: the initial inspection was January 11th, 2025. Notice of violation dated 4/16/2025. Notice of violation compliance date 5/7/2025. Notices of hearing dated and posted on the property 5/19/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 205 55th Avenue on May 19th. This is trash and debris on the left side of the property, as well as overgrown grass and weeds. Just different shots and different angles of the trash and debris that is present on the frontage of the property. Overgrown grass and weeds that are continuing to grow as well. trash and debris on the property. This is towards the driveway and the right-of-way, as well as a fence in disrepair. Pile of trash and debris, mostly palm fronds, and it looks like a mixture of a couple different trash debris underneath. Just a pile of debris there to the left. Broken mailbox up here by the front door. And on the side here, there's a lot of dead vegetation and piled up branches and stuff like that on the back side of the house, on the side there, on the left side, as well as a fence in disrepair. This is another pile in the right-of-way from the property. The corrective action: property must cut and maintain grass and weeds, fix the fence that is in disrepair, and all trash and debris must be cleaned and removed from the property. The property is not compliant. The recommended fine is $250 a day, starting 5/8/2025, until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation.
Thank you, Mr.
Thank you.
Cruz. Is anyone here on behalf of the property owners, either Annie Nguyen or Jimmy Trong? Anyone here on behalf of Annie Nguyen or Jimmy Trong? For the address of 205 55th Avenue, St. Pete Beach? Okay. Have you had any contact with the property owners?
No, I have not. They haven't reached out at all. I've only spoken to a renter that was there, I think about a year or so ago, but I've never actually talked to the owners. I've tried to reach out with whatever information we have in our system currently, and they have not reached out.
Here in California. Okay. All right, I will find that the property is in violation of the stated code sections, and the property owners have 14 days from the date of my order in order to come in compliance with the stated code sections by cleaning up the property, applying for any permits needed for the fence repair, etc. If they don't, we will see them on August 11th, and I will go ahead and look at imposing any additional fines or costs.
Thank you.
All right. Moving on to 5H. Case number 202502232, City of St. Pete Beach versus Fresh Development LLC. Mr. Cruz?
Thank you. Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2025-0231. Respondent is Fresh Development LLC. Violation address is 6800 Sunset Way. Violation description: the property is in violation of section 98-123.1, permits required, 98-65 unsightly conditions, 1A, B, and 4, 98-66 residential and commercial property maintenance, A, B, 24, C, 1, A, B, C, D, and 3 of the Code of Ordinances of the City of St. Pete Beach. Case summary: initial inspection was 4/18/2025. Notice of violation dated 4/21/2025. Notice of violation compliance date 5/8/2025. Notices of hearing dated and posted on the property 5/19/2025. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 6800 Sunset Way, May 19th, 2025. This is in the rear of the property in the alleyway. This is the fence in disrepair, this portion of it. And there's also accumulated trash overflowing out of what looks to be inadequate trash containers for the business associated with this property. This is the unpermitted fence that was erected, assuming that must have took damage from the storms that came in. Just different shots of the overflowing trash and accumulated litter and trash from inadequate trash containers for the business on the property. Got multiple complaints about obnoxious smells. I didn't smell it at the time, but I did the last time when I was just doing a regular reinspection, but it was too late to put it into the notice of violation. And these are different dates with a lot of the trash sitting like this for quite some time. June 20th. And the other one was April 30th. Corrective action. Property must clean and remove all accumulated trash. Supply the business with adequate trash containers or bins for the trash or litter. Fix the fence in disrepair and obtain the proper permit for the replacement of the fence. Property is not compliant. Recommended fine is $250 a day, starting 5/9/2025 until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
Mr. Cruz, anyone here on behalf of Fresh Development LLC? You can please come up here, state your name and affiliation with the business for the record.
Yes, Igor Savic, LLC owner.
All right. Mr. Savage, what would you like to say to the city's allegations?
Okay, I was actually out of country for over 2 months. The property is rental, restaurant rental. I don't own a business. I just own a building, which is kind of unique as a restaurant is built in short-term rental condominiums, or I guess condominiums apartments. So at the beginning, when I was first made aware of this, I spoke to the tenants. They said they have issues a little bit. People are throwing the trash from the condos on the side, just over the fence. I actually had some pictures showing like, bless you. I even have some pictures showing clear bags with beer that they don't actually sell in the restaurant itself. So it was they were going back and forth with the homeowner association and maintenance guys over there. Now that I'm back, I spoke to a homeowner association president. We're gonna have maintenance guys there on the ground check the properties. Usually this happens mainly on Monday and Tuesday when people check out the Airbnb or short-term rentals, as well as they order a bigger container, the restaurant owners did. As far as fencing, I met with Louis, was it last week? One day, and we discussed about me pulling permit. The issue about like why they didn't pull the permit, because the restaurant owner is supposed to pull a permit, they need to get a survey for the property. Well, survey for the property is about $3,000-4,000, some of that. So they didn't want to spend that money, and I don't have a survey because I bought a building and I never had a survey with I have a private loan on it. So this week I'm gonna see. Actually, I'm meeting the city official as far as permitting. See if I can pull the. I can't remember the name of the permit. It's like an administrative permit because there's only 10 feet of the fence that was replaced after hurricane. They want to put something right away so and nobody sees the containers on the back. So yeah, if you look at the pictures, actually you can see old 4x4s are still there. So basically just like 2 sections of the fences are brand new because it was kind of ugly to see that obviously containers because the windows are on the back side of the property. So as far as clean stuff on the back, I'm not sure after I spoke, did you re-inspect the property? No. I went inspect it myself. It was much cleaner. I did speak to restaurant owners as well to clean it a little bit more. There were again some bags. They were not their bags, but again they have to clean it, and I understand. So we're working on HOA. Just somebody sees it every day. And now that I'm back in the country, also I get a little bit of better handle of it. Okay. So tomorrow, 11 o'clock, I have a meeting with city officials regarding the permit. If I can pull a permit without having a survey, I can get this fixed like in a day. If I have to wait for a survey, I might have to have a little bit of time because I don't know, the survey company is probably about 30 days out until I get the survey back. So.
Okay. Great. Anything else, Mr. Slavic?
No, that's pretty much it.
Right, thank you. Anything else from the city? Okay, so I am going to find that the property is in violation of stated code sections. I'm going to allow for 30 days from the date of my order for compliance. In the event that you do have to get a survey, and some of the other testimony has been 3 to 4 weeks out, as you've said, that'll get you time to get the survey. And then we will meet back here. 30 days is going to probably put us in September. So we'll meet back here on September 8th to figure out if you've come into compliance or if there's anything necessary that we need to do, or to impose fines or fees at that time.
Okay, I do have a GC license as well, so that
So
pulling
you
permit
should
is
be
not gonna be an
good,
issue.
okay.
It just-
All right, just make sure I have your contact information, and that way I can send you a copy of the order, that way you have it, and then hopefully I don't see you in September, would be great.
Thanks so much.
And moving on to 5I, case number 202-50067, City of St. Pete Beach versus Lake Merritt Partners LLC.
Thank you, Madam Magistrate. Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement Case Number 2025-0067. Respondent is Lake Merritt Partners, LLC. Violation address is 636 Corey Avenue. Violation description: the property is in violation of Sections 46-33 enumeration 2, 3, 4A, 98-64 general maintenance A, 98-65 unsightly conditions 1A, B, 3, and 4, 98-66 residential and commercial property maintenance A, B, 2A, and B, 3A, 5, 7, 9, 14, C, 2, and 3 of the Code of Ordinances of the City of St. Pete Beach. Case summary: initial inspection was January 11th, 2025. Amended notice of violation dated 4/18/2025. Notice of violation compliance date 5/9/2025. Notices of hearing dated and posted on the property 5/19/2025. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 636 Corey Avenue on May 19th, 2025. This is a deck in disrepair on the property. And the building is obviously in disrepair, taking damage from the hurricanes, as well as trash and debris that has been left on the property. Just different shots of the deck in disrepair. The building also in disrepair between soffits and fascia boards, as well as trash and debris. Just different angles, started to board things up. The exterior wall was damaged. The monument sign is also in disrepair as well and could be a safety hazard for people walking on the sidewalk there. Just different shots at different times throughout the process that the property was going through. They did clean the trash and debris eventually. This is June 20th, 2025. Still in the same state, as well as the broken monument sign. But there still is some debris here on the right side of the property, even though they cleaned the majority of what was on the left side of the property. And that's just different shot of the broken fascia boards. Corrective action: property must clean and remove all accumulated trash or debris, fix or remove the deck in disrepair, fix all areas on the building, fascia boards, doors, windows, exterior wall, etc., or demolish building in disrepair, and fix or remove monument sign in disrepair. Property is not compliant. Recommended fine is $250 a day, starting 5/10/2025, until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
All right, thank you, Mr. Cruz. Anyone here on behalf of Lake Merritt Partners LLC? If you could please state your name and affiliation with the LLC for the record.
Rachel Smith, I'm a representative.
Do you have authority to speak on behalf of Lake Merritt Partners LLC?
I do.
And are you, so my question is, are you associated with Lake Merritt Partners? You a partner?
I work for the owner of Lake Merritt,
Okay, and
Jason Matthews.
and you have written authority to speak on his behalf and represent the LLC here today?
I don't have any, I do not have written authority.
Okay, but it's your testimony here today that he's given you specific authority, and he is the managing partner of the LLC. He has
Correct.
the authority to give you the authority to speak
Yeah.
on his behalf.
Yes, correct.
I just understand, I've dealt with Lake Merit Partners in the past. He's usually been here, if not a lawyer, so I've not seen you before.
Yeah,
Just
right,
want to
right.
make sure you have the opportunity, or you have the authorization to speak on his.
Absolutely. So I was brought into this the beginning of June, the beginning of June to assist with the cleanup and
Okay.
helping because I'm local.
Okay,
With getting
and
things-
Rachel, what is your last name?
Smith.
That's easy, thank you. All right, Ms. Smith, go ahead and anything you have to say in relation.
Oh, sure. So, I have been in touch with Louise Cruz a couple of times regarding this, and Jennifer. I've been sharing photographs, communication. I did get the sign repaired the day, actually, that he reported it, and all the cleanup that was done on the property as well. Even the later photos on that sidewalk, that was all taken care of as well, a few days after he had sent me the messages.
Okay, do you know, so you said it was a few days, I think the last photographs I saw were from June 20th, around?
Yeah, I have June 26th
Okay,
was the final. Did you want to see that?
Yes, please.
Okay, sure. Okay, where do I put this? I'm sorry. I'm sorry. Put it right here? Okay. I have some messages. Oh, yeah. So it's kind of dark.
that's the right side of the,
The rest of that sidewalk area and the rest of the front, and then now it's that final over. I don't have a picture of it, but we rebolted it and attached it. Yes.
okay, and what about the issues with the fascia board and the other decking? Has that all been taken care of as
So
well?
I know all of the debris has been removed, and anything that was hanging was cut, removed, or, just as best that they could. As far as the decking, you're talking about like the wooden, the actual decking that's just sitting on the ground currently? So, okay, I didn't know that needed to be removed, but I can get that scheduled right away.
Okay, and then how about I know there's the boarded up windows, but the fascia board and stuff on the side, are the owners planning on pulling permits and repairing the building, or?
No, my understanding is that it is going to be to be demolished, and they are just in the middle of the insurance claim.
Okay.
And then they're going to move forward with that.
Okay, all right, anything else, Ms. Smith?
I don't think so.
Okay, and Mr. Cruz, from the city's perspective, understanding that, the insurance is whatever it is, the compliance with the boarded up windows, the fascia board, the siding, that kind of thing, when would the city consider that fully compliant? After it's completely repaired, or is there any forgiveness on the fact that they've done substantial compliance?
Yeah, and obviously, as you can see, January 11th was when we seen
Yeah.
this. Then there was a reprieve there for a little while. We kind of backed off, trying to get people back up and going. So then obviously we had to ramp things back up, got to keep things clean. So they've had some time to get things done, a few months here now, almost a half a year, if not a little bit over, depending on when they put in the claim. So they would have to actually be demoed because of the type of violations that I cited.
Right.
It's going to have to actually be gone, or till they get put in a permit, which will give them an extension. If they wanted to fix it, which, as she's alluding to, it's going to be a demolition. But if they did put in a permit, then we can extend so they can go through the permitting process to get that demolition fulfilled.
Okay. Do you know when the insurance claim was submitted?
It was submitted, I want to say it was in October.
Okay, so right after the storm.
Correct.
Okay. Okay, and do you know if the property's been inspected by the adjuster at all, or?
I don't know.
Okay, I know I'm asking you questions you may or may not have the answers to. I'm just trying to make a determination on how much time I should give in order to bring the property in compliance.
Sure.
So I am going to find that the property is in violation of the cited code sections. I understand that the property has been brought substantially into compliance, but there still are some outlying issues with the deck and some of the other things. I am going to allow 30 days to come into compliance, and within that time, that'll put us at the September hearing. I understand that may not get us the fascia board, the siding, the windows, et cetera, but it may get us more information on where you guys are in that process. So keep that in mind if you're back here in September. Please let me know, have the information on where you guys are in the insurance process, what types of permits are going to be applied for, because there is going to need to be some sort of compliance at some point. Understanding there's extenuating circumstances for a lot of properties here, there are not for others, and so we just got to make sure everyone's coming into compliance with the code. So 30 days from the date of my order, we'll see you back at the September 8th hearing, maybe, hopefully not. Hopefully it's all in compliance and everything is good. Please just make sure I have your contact information or whomever I need to send the order to so that I can get that to you.
Okay,
Thank you, Ms. Smith. I appreciate your time.
thank you.
Okay. Moving on to 5J, 202401. Well, before we do this, well, Ms. Duberg already left. Does anyone need a comfort break at all? Are you guys ready to just keep going through? I'm fine. I just didn't know if anyone.
We could keep going, I think. Yep.
Okay, great. All right. I mean, this is probably the longest I've ever been here, so thanks, guys. 5J, case number 20240193, City of St. Pete Beach versus Brightwater Beach Condo Association. Mr. Cruz?
Thank you, Madam Magistrate. Louis Cruz, represent the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0193. Respondent is Brightwater Beach Condo Association. Violation address is 55th Avenue, parcel number 06 32 16 11 40 5 0000001. Violation description. The property is in violation of section 6.12, commercial accessory and temporary temporary equipment, structures, portable buildings and trailers, dumpsters and commercial tents, D3, and 98-123.1, permits required of the Land Development Code and the Code of Ordinances of the City of St. Pete Beach. Case summary: the initial inspection was 4/1/2025. There was a miss up there. Amended notice of violation dated 4/24/2025. Notice of violation compliance date 5/8/2025. Notices of hearing dated and posted on the property 5/19/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 175 55th Avenue, which is their regular address, but 55th Avenue, parcel number 06 32 16 11 405 000 0001 on May 19th, 2025. This was the first unpermitted fence and dumpster enclosure that was being erected on the property in April. It was 2024, excuse me, it was April in 2024. They fully finished the dumpster enclosure. That is the dumpster enclosure there. Just different shots of it. Stop work order that was posted on the dumpster enclosure. That's the unpermitted fence. This is April 22nd. This is the previous dumpster enclosure, which was 2022. Just another shot. This is the same dumpster enclosure that they had for quite some time. This is back from 2017. And so you could see the fence in the background there. It is a new fence as well. Corrective action: property must obtain proper permit for the newly erected dumpster enclosure and fence. Property is not compliant. Recommended fine, $250 per day, starting 5/9/2025 until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And I just want to state, throughout there was one dumpster enclosure. That's why it's from 2024. They were working on getting a permit. They applied for one. It was no movement. It got voided, and then the hurricanes hit, took out the one they erected, and then they built another one without a permit, and that's kind of what we're dealing with here. So it's kind of two unpermitted things that were done.
Okay, so is the violation, are you requesting the violation be cured by securing two after-the-fact permits? Or
It could just
one
be one.
after-the-fact permit for the erection of the fence?
Yes, ma'am, just one
And
for
the
the fence and the
dumpster
dumpster enclosure.
Okay.
Yes, please. And that concludes my presentation.
You answered the question I was going to ask without me having to ask it.
Try to
Thank
make
you,
it a little
Mr.
bit
Cruz.
clearer.
All right, anyone here on behalf of Brightwater Beach Condo Association? You can all come up. Please state your names for the record and your association with the association.
Thank you. Good afternoon. I'm Scott. I'm the property manager for the community. And
Scott, what's your last name?
it's Vignery.
Vignier?
Vinetti.
Vignetti. I tried. Okay.
And then I have a board member here. This is Brandon Kay. I'm owner of 203.
Okay.
My name is Matthew Ryan. I was hired to get it permitted after the fact.
Okay, perfect. All right, who wants to talk? Go tell me what's going on.
And I just gave an update to Mr. Cruz. We are just waiting on an amended site survey.
Okay.
That's in the works, so that's basically what we're just waiting on right now.
Okay, so you've already applied for the after-the-fact permit for both the dumpster enclosure and the fence? Okay, and just waiting on the site survey in order to submit with that package to get the permitting?
This is only a few minutes ago. We're just waiting on the site survey.
Okay. Do you have any idea how long that will take for?
They are very slow. 3 to
Yeah.
4 weeks is just a preliminary. I mean, it'd be nice if we could get 60 days minimum to
Okay.
get our permit active.
Okay. All right, anything else, you guys?
That's it.
All right, sounds good. Anything else, Mr. Cruz?
Oh, I'm sorry.
No, you're fine. Anything else?
No.
Okay.
Yeah, I spoke with them out there. They said they're, making rounds to get it done.
Actively
properly.
working.
Just don't do any more things without the permit.
Stop doing unpermitted work. Got it. Okay. All right. Well, I am going to find that the property is in violation of the cited code sections. I am going to allow for 60 days from the date of my order in order to secure a permit. So not just the application for, but secure the after the fact permits both for the dumpster enclosure and for the fence. Hopefully I don't see you, but if we need to, that will be an October hearing, so October 13th. And just make sure I have someone's contact information so that I can send you the appropriate order detailing all of that information.
Okay, thank you.
All right, thank you, gentlemen. Have a great day. All right, moving on to 5K, case number 2024069, City of St. Pete Beach versus Jennifer Franco.
Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0699. Respondent Jennifer C. Franco. Violation address 490 82nd Avenue. Violation description. The property is in violation of section 98-123.1. Permits required of the Code of Ordinances of the City of St. Pete Beach. Case summary. The initial inspection was 12/17/2024. Amended notice of violation dated 4/2/2025. Notice of violation compliance date 4/16/2025. Notices of hearing dated and posted on the property 5/19/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 490 82nd Avenue on May 19th, 2025. Here's part of the garage, and as you can see there is a difference of the drywall there, and that is where they did an unpermitted drywall reinstallation. After the hurricanes, they installed a new exterior door, which does need a permit, as well as unpermitted drywall to the left side there. Just a better shot of what was done. They redid the drywall. I guess there was vents there or whatever they were doing there. Different shots of the new drywall that was put in. This was them doing different drywall stuff as well as electrical stuff and moving the fridge. That was the stop work order that was placed on the property while they were redoing the floors. Corrective action. Property must obtain proper permit for all work done from the post-storm renovation. Property is not compliant. Recommended fine is $250 per day, starting 4/17/2025, until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
Thank you. Is Ms. Franco here or anyone here on behalf of Ms. Jennifer Franco? Jennifer Franco or anyone here on behalf of Jennifer Franco? Mr. Cruz, have you had any opportunity to speak to the respondent at all?
Yes, Ms. Franco is from Nevada. She came out here one time, never got a chance to meet with her. She said she was working on trying to get permits and try to get a contractor. As you can see, I gave her ample time, obviously, through all this stuff that's going on. We're trying to give a little bit of reprieve so people can find contractors and get the work done properly. So I've reached out to her and let her know, you know, hey, we're got to kind of ramp up something here, and she hasn't reached back out. She hasn't applied for a permit or anything of that nature. She still has permits that need to be finished out from a couple of the other things that she actually did get permitted that she fixed from the hurricane damage. So, but I have not talked to her recently, no.
Okay, all right, thank you. All right, I am going to find that the property is in violation of the stated code sections. I am going to give the respondent 30 days from the date of my order to apply for a permit for the after-the-fact permit for the, so here's my, so the stop work order is still on the property?
I don't know if they removed it. I think the last time I drove by there, it was still up.
Okay, but no further work has been done, so it's just sitting?
They actually have renters in there right now. Yes.
So they completed, all your pictures were half-finished work. They completed all that work in violation of the stop work order that was posted on the property?
Yes, ma'am.
There's no violation in front of me for violation of a stop work order, right?
Mm-mm.
Okay. All right. All right, so that changes my analysis a little bit. Since the property has already been completed, I'm going to allow for 14 days from the date of my order in order to apply for a permit and after-the-fact permit for the outstanding work that was done on the property. And if we don't get that done, applied for, then we will see her or you, somebody in August.
Thank you.
Okay, moving on to 5L, case number 20250287, City of St. Pete Beach versus Shannon Hunter.
Thank you, Madam Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2025-0287. Respondent is Shannon Hunter. Violation address is 650 59th Avenue. Violation description: the property is in violation of sections 46-33 enumeration 2, 98-66 residential and commercial property maintenance A, B, 22A, C, 2 and 3, and 98-66, or excuse me, 98-65 unsightly conditions 4 of the Code of Ordinances of the City of St. Pete Beach. Case summary: the initial inspection was 5/5/2024. Notice of violation dated 5/14/2025. Notice of violation compliance date 5/25/2025. Notice of hearing dated and posted on the property 6/4/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 650 64th Avenue, June 4th, 2025. This is a pile of trash and debris left on the property at 650 64th. There's trash and debris left on the property, as well as a dead tree there to the left of the screen just a tad. Starting to overgrow a little bit, but mostly just palm fronds, branches, stuff like that left on the property. There's a pile of debris that later showed up on the property in the right-of-way and on the property near the driveway on the right side. And some palm fronds and different type of stuff that was on the property. Corrective action: property must clean and remove all trash and debris from the property and have the dead tree cut down and removed. The property is now compliant. I would like to show the compliant pictures. If you could do the overhead for me, please. Thank you. And all the debris and all the palm fronds, trash, stuff like that, and the dead tree has been removed. So the city will not be asking for any fines, but will be asking for the $329 for the administrative costs.
Okay. Anyone here on behalf of Shannon Hunter? Or is Shannon Hunter here?
I talked with her. She said she wasn't going to be able to be here, but she did reach out to me a little bit ago. I think it was last week, and I went and re-inspected this morning to make sure we could close it out.
Perfect. All right, well, I am going to find that the property was in violation of the stated code sections. I'm going to find that the property is in compliance as of 7/14/2025. I'm not going to be assessing any fines with the property, but I will assess the $329 in administrative costs. Okay.
Thank you.
5M. Case number 202404070, City of St. Pete Beach versus 333 Capital LLC.
Thank you, Madam Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement Case Number 2024-0470. Respondent, 333 Capital LLC. Violation address, 540 71st Avenue. Violation description, the property is in violation of Sections 46-33, enumeration 2 and 4. B, 98-65, unsightly conditions 4. 98-66, residential and commercial property maintenance A, B, 2A and B, 7, 11, C, 2 and 3, and E of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection, 7/31/2024. Amended notice of violation dated 5/13/2025. Notice of violation compliance date, 5/27/2025. Notices of hearing dated and posted on the property, 6/4/2025. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 540 71st Avenue on June 4th. This is what the property looked like before the storm. This was trash and debris and outside storage of equipment and material under the carport there, and things that started to get outside of the property. Just a different look, has a fridge and all different types of equipment and material being stored in public view. This is what it looked like after the storm. The property lost their carport, started to remove a lot of the stuff, or it was damaged, but still has some outside storage there. They also have a fascia board in disrepair, deteriorated paint on exterior wall, and roof shingles in disrepair there on the corner. Corrective action, property must clean and remove all trash and debris from the property, have all outside storage of equipment or materials removed or screened so that it is not visible from public view. The deteriorated paint on the exterior wall must be cleaned and painted, and the roof in disrepair, or the shingles, I should say, in disrepair, along with the broken fascia boards, must be repaired. Property is not compliant. Recommended fine is $250 per day, starting 5/28/2025 until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
Anyone here on behalf of 333 Capital LLC?
Yes.
If you could please come state your name and affiliation with the corporation, and also thank you for your patience.
No problem. My name's Paul Billups. I live there.
Okay, and what is your affiliation with the property owner of the LLC?
I live there.
Are you the tenant there, or?
Yes, ma'am.
Okay. Do you have authorization to speak on the property owner's behalf?
Yes, ma'am.
Okay. All right, and could you just explain to me what your response is to the allegations from the city?
We have some of the construction work done and painted up on the inside. Now, the people that has got to put the carport back on and the facial board was the ones that repaired like where the board went across the side of the house where it was ripped off. They repaired it, I painted it, but the guy had a heart attack like 3 weeks ago. So I don't know when he's going to be able to come back and do that facial board and the carport. Now, as far as everything else, the chairs and stuff, we had them.
You can have the chairs in regular, outside sitting.
We're just waiting on. Now, we had the big mangrove tree, and we had it cut down in the back. That was so we're just now, and we had a Wally Watt building. They got smashed up, and we got it done. We're just waiting on the contractor to come back and do the carport. Now the paint, I sent a picture to like Miss Jen.
Jennifer, yeah, okay.
We just got the paint this past week.
Okay, so right now you're just waiting on the contractor to finish out the carport and fix the fascia board and?
Yes.
Okay, and I know this, he just had a heart attack, but do you have an estimate on how long it might take for him to come back?
I haven't talked to him. My wife's a nurse. She happened to see him when they brought him in. It's the only reason we knew about it.
Oh, gosh.
So.
Okay. That does complicate things a little, because obviously you want it to be done, and I need to be able to give the city a time frame to have it completed. Also, you need to have a time frame to have it completed. Anything further from the city?
I just want to add, just so that we have it on record, if he's going to have the carport go back in, just make sure you get the proper permits. You don't want to cause another violation.
Yeah.
Right.
Yeah, that's the owner doing that, yeah.
All right, so the owner, and I assumed when you had a GC that the owner was contracting to pulling the fascia board, all the permits for that. So that's a good point. Thank you, Mr. Cruz. Okay. Let's do it this way. I will, I'm going to find the property in violation of the stated code sections. I'm going to allow for 30 days from the date of my order to come into compliance, and we will come back here in September just to determine whether or not it happened, or if there's been a good faith effort, or if you needed to secure a new contractor, or hopefully he's better and he can get back to work. But
I hope he gets better too.
yeah.
Thank you very much.
So I will allow 30 days from the date of my order. Just make sure I have your contact information, or whoever's contact information I need to send the order to.
Yes, ma'am.
All right. Thank you so much. And thank you again for your patience. All right. Oh. We are getting towards the end, guys. I see a light at the end of the tunnel. Okay, moving on. 5N, case number 20250-339, City of St. Pete Beach versus Rhonda Schroeder.
Thank you, Madam Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2025-0339. Respondent, Rhonda H. Schroeder. Violation address, 640 59th Avenue. Violation description, the property is in violation of sections 46-33 enumeration 1A and 2, 98-65 unsightly conditions 4, 98-66 residential and commercial property maintenance A, B, 20 and 22A of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection 6/2/2025, notice of violation dated 6/3/2025, notice of violation compliance date 6/17/2025, notices of hearing dated and posted on the property 6/20/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 640 59th Avenue on June 20th, 2025. Here is the overgrown grass and weeds, and there's also a dead tree there in the background, right in front of the fence. Just a different shot of the property. Overgrown grass and weeds, dead palm fronds, branches, stuff like that on the driveway, as well as in the corners here on the left, and the dead tree. And this is on the right side of the property. Corrective action. Property must clean and remove debris from the property, cut and maintain the grass and weeds on the property, and have the dead tree cut down and removed. Property is not compliant. Recommended fine is $250 per day, starting 6/18/2025 until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
Okay, thank you, Mr. Cruz. Is anyone here on behalf of Rhonda Schroeder, or Ms. Schroeder here? Anyone here on behalf of Rhonda Schroeder? Property address 640 59th Avenue, St. Pete Beach. Have you had any contact with Ms. Schroeder?
No, I have not. We sent out, obviously, certified mail and try to use, sometimes we have phone numbers, emails. I don't think we had too much information on her. I can't remember.
Do you know if the property is being if it's occupied?
To my knowledge, no, and I actually drove by today when I was doing some of my re-inspections that I talked about from the continued cases. I did see a huge trailer and some type of machine, so it might be getting demolished.
Okay.
So obviously I'll keep tabs on that, but I didn't get a chance to check to see if they had a permit by the time I got back this morning. But to my knowledge, no one's living there at this point.
Okay. All right, I am going to find that the property is in violation of the stated code sections. I'm going to allow for 14 days from the date of my order in order to bring the property into compliance. If it's not, then we will meet at the August hearing and talk about assessing fines and fees.
Thank you.
Okay, moving on, 5-0, case number 202400584 is going to be continued until the August 11th code enforcement hearing, and I will give an order to that effect.
Thank you.
Moving on to 5P, case number 202400707, City of St. Pete Beach versus Chris Spencer.
Thank you, Madam Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0584. Respondent, excuse me, got this one continued. This is Code Enforcement case number 2024-0707. Respondent, Chris Spencer, violation address 140 Corey Avenue. Violation description, the property is in violation of section 98-123.1, permits required of the Code of Ordinances of the City of St. Pete Beach. Case summary, the initial inspection was 12/28/2024. Amended notice of violation dated 4/2/2025. Notice of violation compliance date 4/16/2025. Notice of hearing dated and posted on the property 6/24/2025. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 140 Corey Avenue on June 24th, 2025. This is looks to be like some type of business across the street here. This is the unpermitted post-storm drywall reinstallation as well as electrical work that was done because the outlets are pretty low, as you can see there on the left side of the drywall there. Mostly they just redid the drywall in different section of this property. Corrective action, property must obtain the proper permits for the work done without a permit, being the drywall and the electrical. Property is not compliant. Recommended fine is $250 per day starting 4/17/2025 until compliant, plus $329 for administrative costs and any lien recording fees that may be associated with this case. And that concludes my presentation. Thank you.
Okay, is Chris Spencer here or anyone here on behalf of Chris Spencer? Anyone here on behalf of 140 Corey Avenue, St. Pete Beach? Nobody. Mr. Cruz, any contact with the property owner?
I did talk with the property owner a little bit after I seen the unpermitted work getting done. They were already finished. I got to talk to somebody that was there that said he was a friend, but then the property owner came in to get the information that was needed to pull the permit. So he actually came in and talked to a permit technician,
Okay.
But he never fulfilled the permit nor applied for it either. So I haven't heard from him. Not sure why he's not here today, but there has been no permit applied for at this time.
Okay. All right, I am going to find that the property is in violation of the stated code sections. I am going to allow for 14 days from the date of my order and in order to apply for the after-the-fact permits. And if they do so, then great, we won't see them in August. If they don't, then we will see them in August.
Thank you, Madam Magistrate.
And we've already taken care of Q.
Yes.
So we have a lien reduction. I think there was one more case that we wanted to add, is that correct?
Yes, please.
Okay. Is it something other than a lien reduction?
It is something other than a lien reduction, just a final order. This property was sold after the hearing, so
Right.
we would like an order basically outlining the administrative cost.
Okay, let's go ahead and do the lien reduction, then I'll get all the case information on that one and get you guys the order administratively. So lien reduction is 8A, case number 202400081, City of St. Pete Beach versus 4401 Gulf Boulevard LLC.
Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. Case number 2024-0081, 4401 Gulf Boulevard. If you recall, this case came to you with a challenge to the fine amount. I just want to bring that to your attention. As you consider the request for the fines to be reduced to $5,000, so that, and for the record, so that you know, and for the record, the fines total $8,098.50, which includes administrative costs and filing fees. So the total lien is $79,750, and the city will request that full amount.
All right, can you put my order back up there, please? So I can refresh my recollection a bit. Okay, I remember.
And this is the order imposing those fines.
Okay, I do recall that, okay. All right, is the respondent, or anyone on behalf of the respondent here, 4401 Gulf Boulevard LLC? If you could please state your name and affiliation with the property owner for the record.
Hello, Wesley Shaw, District Manager for Walgreens St. Pete.
And I'm assuming since you are the district manager, you are responsible for the tenant in this location?
That's correct. Yeah.
Okay.
The store, not the landlord.
Okay, understood. All right, since you are the applicant, can you please go ahead and just tell me what is your reasonings for the request for the lien reduction?
Sure. Basically, at Walgreens, we've got two processes for damage and maintenance repair. One is regular, just everyday stuff, and then there's an escalated process for urgent or legal citation things such as this. So initially, when this happened, we were unaware that the city even knew about it. We had in the regular process, and we were, until the notice was posted on the door of the store that fines were beginning, we were unaware that this was even something that was being looked at, right? So I escalated that immediately. So initially, it wasn't forwarded through the company's appropriate parties for handling that in a timely manner. Permits took an unusually long time to receive because of the hurricanes, inspection delays, and permit closeout timing. We had to endure 2 hurricanes over this last year, which caused a tremendous amount of construction-related delays, from drawings needed, contractor scheduling. I can't tell you how many times the contractor changed the date that they're going to do the work, and then the permits as well. The entire cost of the fix was less than $5,000. The fine's currently 18 times that. And the store, this damage was initially caused by a customer's car and not noticed right away, so it was not something that you can see from the parking lot. You have to go to the other side and inspect it from the other side. So it wasn't like it was a negligent thing. It was more of a we were the victim of this happening. And we were in the process of fixing it, but it did take a long time. We've never been in violation like this before in St. Pete in my tenure, 23 years, St. Pete Beach. So first offense, so request for leniency there.
So I do have a question, because you all are the tenant at that property, and understanding you didn't get notification because the property owner was the one who was cited for the violation. Is there a term within your lease with them that you would be responsible for all code violation fines?
I'm unaware.
If you can disclose it, or even if you know?
I don't know.
Okay. The only reason I ask is because if I say that there's no fine reduction amount, this is going to go as a lien on the property against the property owners, and understanding that you are telling me now that you guys as the tenant didn't even know, but you're responsible for fixing it, that does kind of change my analysis a little bit. Because if there's a trigger in your lease or something that says, great, you're now responsible for any fines on the property. I want to make sure that you're not getting hit with something that wouldn't have ordinarily been your responsibility.
Yeah.
Especially when you were given, according to your testimony, you were given notification sometime later.
So when something happens at a store, that's, whether it's when it's a landlord-owned operation.
Property, right.
From my level down, the responsibility is noticing it, opening a ticket to have it fixed.
Okay.
And then beyond that, they make the decision whether or not it's something
That's above your pay grade.
I guess so, yeah.
Yeah.
And we did that, but I don't know if the landlord was getting notifications from the city and.
So the landlord was here when we had the first hearing. They appeared, and they were the ones who said that they were responsible for getting it fixed within the time frame before the fine started to run. So that's why I'm having, the question is, this is coming from the property owner, but you're here as a representative of the tenant asking for the lien reduction. So that's it. I mean, if you don't know, you don't know, but I'm just trying to figure out who's actually being assessed and going to be responsible legally for whatever the lien amount is, because that does make a difference in my determination. It would be helpful to know that information. Okay. Right, anything else, Mr. Shaw, that you'd like for me to know?
No, just that, anything that has ever come up from the city, we've fixed in a timely manner. This is one aspect that took a long time for some extenuating circumstances.
I can understand that. All right, thank you very much. Anything further from the city, Mr. Dewar?
No, Madam Special Magistrate, other than the fact, as you mentioned, property owners were here at the last hearing. Thank you.
Sorry, I'm looking at the city's code. I haven't just shut down altogether.
Thought you were ordering lunch.
Yeah. Okay, so criteria for reduction. So I am going to kind of use, and I think I've done this in the past, the same criteria as the fine imposition is the same kind of criteria I'm going to use for the reduction of the lien. This one's a little bit different because the violator in this case, who is the one who is, I guess the violator, quote unquote, is the one who is requesting the lien reduction, is not the property owner, and the property owner was the one who asserted that it would be completed within a specific period of time. I do not know what the lease looks like. That would be helpful for me from an equitable standpoint in determining whether or not a lien reduction was to take place, because it sounds like to me the credible testimony I heard today is that this would have been taken care of sooner if there had been notification made to the tenant to escalate this as a legal matter through their processes, and it could have potentially been avoided altogether. So I am going to grant a lien reduction request, but not to the $5,000 as requested. I am going to, well, let's see. The original lien imposition was $88,750, so I'll reduce that to $8,750 for the lien and keeping the $368 in administrative costs. And then that needs to be paid within 30 days. If it's not paid within 30 days of the date of my order, then it will go back up to the full $88,750. I wish I had more information with regarding who would be responsible for this, but that's a reduction to 10% of.
Correction, Madam Special Magistrate. I know you just mentioned 89,000, is that correct? Or 88,000?
$8,750.
It totaled $79,750,
That's
plus the admin and filing fees.
Interestingly enough, that's not what the paperwork that
I
is
agree.
in my packet
Correction.
says.
You are, yeah.
Okay, so what is the total? The lien amount was
750.
79,750.
But you can still keep it at your...
No, that changes my, thank you for bringing that to my attention, that changes my math. So then I am gonna reduce that then to $7,975. And then with the $368.50 for the costs, because I do not reduce the costs. And I will get the appropriate order to the appropriate parties. Mr. Shaw, if I need to, please make sure I have your contact information. I will also
Madam
send it to
Magistrate,
the-
that was to be paid within
within 30 days of the date of my order.
30 days. Thank you.
And that will be included in that order. And I am going to send a copy of that order to the Bateses as well, since they are the property owners. I think they need to be made aware of that.
Do you just need name and,
If you have an email address or something, that would be, yeah.
you want me to put,
Yeah, if you could put that on there, that way I can go ahead and send it directly to you, and it doesn't get lost in the mail or whatever else happens nowadays. We have no cases complied, no old cases. We've done the lien reduction. Okay, so the additional case is, we need an order. Please give me the case number, Mr. Dewar.
Case number 2025-0035, 3111 South DeBasin Avenue. Case number 2025-0035, 3111 South DeBasin Avenue.
Okay, and we need an order
For the admin costs.
just for admin costs.
Thank you,
The
ma'am.
property is in compliance?
Property is now compliant, yes. ma'am.
And what date do you know the property came into compliance?
It was in compliance before the date of your order.
Before the date of
last order.
Okay.
And then it sold literally the day after it came to Magistrate.
And sold the next day, okay. All right, and then in addition to the city, is there a new property owner that I need to send this to?
I'm in contact with the real estate agent, so if you send it to me, I can forward it to him,
Okay, I'm also gonna send it to the property address that way,
or whatever's
on the property appraiser's website. Okay.
You
All
said
right.
June 9th, June 10th?
whatever the date's in. Came in compliance before that date.
I can put that, it just came in compliance before the date of the hearing.
If you go to the overhead, you will see your order, yeah. But
Yeah.
yeah.
Perfect. All right, I can do that. All right, I will get that order out. I will send it to the property address as well as to the city. One thing I did want to bring up, because I did mention the October hearing, I may very well, it's looking like I will not be available for that October hearing, so I don't know if you guys want to look at changing the date to a different Tuesday, or if you want to see if Mr. Thanis is available in order to
Yes, ma'am,
Mr. Thanis
continue.
is available to handle that hearing.
Yes, ma'am. We will consider it and keep in touch with you.
Okay. I did have one order that I put the October date. I'm going to make a caveat on that order to say October 14th, and, or unless it's amended or something to that effect. That way it's already included in the order and you guys don't have to worry about advertising on that case.
Very good. Thank you, ma'am.
All right. Anything else that we need to discuss while I am here?
And while it's not raining,
Well, oh, good.
Oh,
we need to make a break.
your case was heard, as I mentioned to you.
Too bad I was never notified of it.
I've already made my ruling on that case. Give me a second.
What case was it?
How come you were not notified? Was a notice not sent to him?
I mean, I sent it and it wasn't returned to me.
Yep.
And you were at the last hearing, so you would have known that it was a hearing for today. Right, Mr. Donovan, correct?
It's in the beginning.
Oh, yeah, it was under the... Yeah, Mr. Donovan, I heard that case almost at the beginning of the hearing. The fact that you weren't notified is disingenuous to me, considering you were at the last hearing when I told you it would be heard today. So you knew the date that this was going to be heard.
I had no idea when it was supposed to be. As it was, I asked for, the thing was so confusing. These two people were going back and forth as to how many ordinances I was breaking. And then they were also supposed to look for a building permit for my pad, for my motorhome.
No, because that wasn't included in my order. And my office mailed you the order that had all the details in it. That wasn't even included. All it was the outdoor storage was the only thing that was left besides, I think, some of the other stuff. So regardless,
Correct.
and that was taken care of. Right.
And they've all been gone.
And
The fence has been repaired.
then the outdoor storage of all of the things that were sitting in front of your home.
That's a motorcycle.
That is not the...
Registration, because I had that.
It had nothing to do with the motorcycle, the RV. It had to do with the other automotive equipment that was sitting out front.
That's behind the motorcycle is that the table that I used to work on. And
Right.
right now, the only thing that's on it is a weed eater, because I got to cut the weeds. I can just cut the grass, but I can't do the weeds. So I got that fixed.
All right. I have already heard this, Ms. Stupak. You are the city attorney, so I am going to defer to you whether or not you are objecting to opening up the hearing again and hearing additional testimony.
I would prefer, I hate to do it, I know it's late in the day, but I would prefer to go ahead and give him the opportunity.
Okay. Then, okay, Mr. Donovan, we'll go ahead and, I did already rule on that. Well, we are going to open up the hearing again to make sure that you have an opportunity to speak in your defense. The city presented evidence demonstrating, well, testimony demonstrating that the property was in compliance with the fence. We didn't have an issue last time with the concrete pad or the RV or the motorcycle because you brought the registrations. So the only issue was the outdoor storage of the table and I think the lawnmower equipment, some of the other stuff that was there. So before you have an opportunity to speak, can I get you to raise your right hand so I can swear you in? Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Mr. Vaughn. You can come up here and you can, please, on the record, tell me that your point on if the property is in compliance or not.
The tractor has been repaired. The trailer, there was originally, there was a tractor there
Right.
because I was doing the tires on it
Mm-hmm.
and the deck. And then they didn't like the tractor, the trailer that goes on the tractor, so they're both in the back.
Okay.
And the other thing was the fence. And I know you were telling these fellas here to look up the building permit for the pad.
And I think I never ruled. I said, you know what?
Okay.
I have credible testimony. They said they couldn't find a permit. I believe that you had it, so that I didn't even find you
Okay.
in violation of that one.
But as far as I know, that's all I had to do. And there's a table that goes up and down so that I can work on things. And right now, I just put my weed eater there because I got to take that apart because that's seized up. That was just put there yesterday.
But
But
before that
But the
table,
table is behind the motorcycle, and the motorcycle is underneath the tarp.
okay, so what you're saying is you can't see the table from
From the street.
the street. Okay.
And I have the motorcycle raised up for two reasons. One, another flood, which I might not have a rear.
Okay.
The other is it makes it more difficult for somebody to decide to take.
And then you also said that table is incredibly heavy, so you don't move that inside and out, but now you've moved it so it's behind
Well,
something
it was behind before.
before. It was just,
What it is it's heavy, but it also has the ability to lift things up so that I can work on them and lower them back down to
so
the
if
ground
it's
level.
lower, you can't see it. If it's lifted up and has stuff on it, you could see it.
You still can't
You
see
still
it.
can't see it.
Unless I put something really tall on it and there's nothing on it except a weed eater.
Okay, and all that other stuff, all the other automotive stuff has been cleared from your
The
front area?
the only automotive stuff that I know of was the tractor and the trailer.
tractor with the, okay, okay. All right. Mr. Cruz, this was your case?
Yes.
Okay, do you have any photographs or, okay,
I just wasn't able to print them out earlier. Our printing was acting funky because it's storm in the
Okay.
system, so I do have one here, excuse me.
okay. And when did you do your last inspection?
Just this morning.
This morning.
That's okay, you got 650, 59 screwed up with the one over there on 64th too, on the pictures up there. Which they're not mine, I just noticed them while I was going through.
Can you put on the screen, please? Thank you.
And it's my lawnmower.
So that was this morning? I can turn my head, it's okay.
Yeah, sorry. Sorry
That's
about that.
fine.
I guess it.
That's okay, you got a 1920 Dodge coming at you there.
Okay, so it's you're talking about the lawnmower, the tires there. Okay, the fence is good, we said, right?
Yes.
And then the other picture is?
That's my garage.
Yeah. So is this?
Oh, that little thing there, it's on the right of the red thing, that's my garbage can for the local. I just rolled that out of the garage so that I could get out this morning.
And the table, I can't go upside down, so you can't be doing that.
There we go.
And the table that you're talking about is over here behind your truck, behind the motorcycle to the
That's
left,
correct.
right? Yeah, okay, I don't really
The
have
thing with the
problems
two
that.
orange things on it, I had to pull out a post to get
For the fence?
in the back.
Okay.
And, the storm deteriorated those. But it's on a little cart that I rolled out. I had it inside the garage door.
Okay.
I took it out this morning, and I
And-
left the house about 8:30.
Okay, so the two dollies, the little trash receptacle, and then the other little table on wheels, those are not typically there, those you wheel in and wheel out, correct?
Mostly, yeah, but the red one on the right is for moving the chlorine jugs around the backyard.
Mm-hmm.
And the one on the left is when I go to the grocery store, I put groceries on that because it's a flat one.
Okay. And then over to the right, that cylindrical?
That's my filter for the pool.
For the pool. And you were working on that, so that's not typically there.
No, I alternate them every couple of days because the pool is such a mess. I can't keep up with it. I change the filter about every 2-3 days and bring it out in front and rinse it off.
Rinse it off, and then you leave it there to dry, and then you put it,
I hope the sun does a good job of killing the algae too.
yeah, okay. So
And
you're
the
just,
the red thing, it's
Yep.
like a waste basket.
Yep.
It was a vacuum cleaner.
oh, yeah, like a wet dry vac. I see what you're
Yeah,
saying.
That's it.
And then
so
you
it
just took
makes
the
it-
top off.
Yeah, the top is gone. Garbage men took that. Hope the
Okay.
garbage men took that one tire that I forgot to roll out there, but there were 2 more out there for them to get.
Okay, so the things that, your testimony here today is the things that are presently sitting out here in this picture that are from this morning are not things that are typically there, those are transient things.
Yes.
And so they're not outdoor storage, it was just an unfortunate happenstance that the picture got taken when it did. Okay. All right, anything else, Mr. Cruz or Mr. Dewar?
Yes. Madam Special Magistrate, we've had a history on this property, and because of that history, listen, I know Mr. Donovan likes to tinker, and he's well within his rights to do that, but this is a continuation, almost a recurrence and is why we brought this case. So the neighbors find this an eyesore. As much as he can put it in and out of the garage, the issue is it continues to remain on the driveway.
And I can appreciate that, but keep in mind, under Chapter 162, if you catch him with a violation, he wheels it in the next day, violation is cured if he keeps it in there until the hearing, right? So while I can understand that there might be other legal mechanisms that the city can look to try and enforce its code as it has in other properties, but I find Mr. Donovan's testimony to be credible. I don't have any reason not to believe him. The things that were demonstrated in the first round of pictures from when we had the hearing where I found the violation are no longer there. And so I'm going to find that the property did come into compliance. I am not going to issue I'm not going to issue the fines, but I will assess the $329 in administrative costs. So thank you, Mr. Donovan, for coming here today. I will get you an order to that effect. So you're very lucky this went very long and you caught me and that the city allowed us to reopen the hearing.
For the heck of it, how did you mail it to me if I haven't got it in the mailbox?
I don't know how. I never got anything returned to my office. I sent it to the address that's in here.
What is the address that you have right there, if you don't mind?
Your property address, 820 59th Avenue, St. Pete Beach, Florida, 33706.
A mailman comes by there every day, almost 4 o'clock.
So the city mailed certain notices. I mailed my order. If there's a better way to get it to you, a better address, please let me know. If not, we've not had problems with the mail carrier.
There's 2 letters that are gone.
Yeah, I sent, the order came from, one came from my office.
Yeah, I've never gotten anything. Those are 2 letters, and most of the stuff is thrown right in the garbage can as I go by.
Well, you might have thrown my letter away then.
No, usually if it's got something that said prepaid.
No, mine will say my law firm, it will have my law firm's logo on it. Will say Trask Daño. So it might have been something that you threw away because I don't like getting stuff from us either.
I didn't see anything that said law firm. I didn't see anything from St. Pete Beach because they got that colored thing.
Right. Well, just understand, I am going to send another order. It will have that. All it's going to say is you came into compliance, but we are assessing the $329 in costs for the administrative costs of the city, and that's it.
But I also noticed that a lot of people are changing my address to St. Petersburg.
I did not. That was St. Pete Beach. I made sure I got it. So, because I checked the property appraiser's website before I mail anything out.
It does duplicate to St. Pete
St.
North.
Pete. Oh, that's funny.
I had a brother-in-law that worked in that post office up there, and he used to send us little notes as it would go up there. And read the little stamp there.
Gotta love the postal service. All right. Well, thank you, Mr. Donovan. I appreciate your time today. And if there's nothing else from the city.
Basically, just, when we get complaints, it's just be mindful. That's all. Just, wheel your stuff in and out, and we won't be anywhere near you,
Well, once I roll that in, then I can't go all the way through.
It's a lot of equipment.
All right, guys. It's been real. It's been fun. It's been real fun.
And it's not raining.
Yeah.
Make your
Get out
escape.
before it starts to rain again. And we are adjourned at 2:47.